Good evening. Welcome to the Board of Zoning Appeals meeting for May 8th of 2024. The meeting is now in session. My name is Francis Sweeney. I am acting as the substitute chair, and I will introduce our board from beginning on my far left, Brian Falkowski, Ashley Garkar, Davey Rowan, and Todd Goling. To my far right is Heather Freeman, our Township Zoning Inspector, and to my far left is our legal counsel, Bridie Matheny. Under the advice of our legal counsel, we ask that anyone speaking tonight must be sworn in. If you plan on speaking, please stand up and raise your right hand. Okay, do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Yes,
sir. Thank you. Please be seated. When presenting your case or commenting, please come up to the microphone here, state your name and address for the record. Heather, were all the legal notices published in a timely fashion?
Yes, they were.
Thank you. Okay, this evening we have a number of matters on our agenda. We have no old business, and we'll get right to the new business. And the first matter is a variance application titled 2024-151, Wixford Properties, LLC, on behalf of the property owners, Edward and Karen Jividen, is requesting a variance from Section 15.04B1 and 2, Section 15.04A2D, to allow for an addition onto the dwelling that will have a front building setback of 33 feet in lieu of the minimum 50 feet required from the side street. This is for the property located at 6820 Rolling Acres and being permanent parcel number 08-A-031-E-00-024-0. All right, you may approach and present your case.
Absolutely. Good evening, people.
One thing I probably should clarify is we need a 3-vote majority to pass any measure or to deny any measure.
Okay.
And just so you're aware of that.
Okay. My name is Paul Contorno, owner of Wixford Properties. We're looking to get a variance approval for a third car extension garage and also an extension of the back of the house for a laundry room.
Okay.
Okay.
Did you state your name and address?
Name and address. I think
Yeah.
we got your name. Just need your
my address.
Your
Yeah.
7209 Gabriel's Landing.
Okay, go ahead.
One other thing, Mr. Chairman, I'm sorry to interrupt. And can you confirm whether you've been sworn in?
Yes.
Thank
Yes.
you.
Okay, now you can go ahead.
Okay. So right now there's a 50-foot setback, right, existing, and after the addition, it'll be a 33-foot setback. It's a corner lot on Rolling Acres that adjacent to Bryan Street. Okay, and I mean, I really don't know what else to say other than, I mean, I have the homeowners here. They have a letter that they have submitted, and they have a letter with them, and they also have had neighbors that have agreed that they're okay with this.
You the builder.
Yes, correct. I am the contractor.
What's the total square footage that's going to be added?
I think it's 700 square feet.
That's good enough.
Yeah.
Approximately.
It's the garage plus 8 foot by 20 foot of an extension of the laundry room.
Okay.
And so if I'm facing the garage you're adding to the right of the garage, if I'm looking at the garage.
It is facing Rolling Acres.
And so the addition would be to the right. as
The
you're
addition
facing
is behind.
behind.
It's behind and
Correct.
over, so he'd be going towards Bryan Drive or
It's behind and to the right. Like it's an L
Yeah,
shape,
it'll
correct?
be
That's
approaching
correct.
Bryan Drive.
okay.
Correct.
Yeah, so this is the garage.
Right, so if I'm
So
facing,
it extends
okay, so
over.
it goes towards the
So if
garage.
it wasn't a corner lot, it was just a regular lot line, he'd be.
Right. So you got the 2-car garage, and then we're just adding the third,
That's
and then behind that is the extension.
got it.
Correct.
Okay,
So.
all right. Anybody have any other questions? Are you the homeowner? Yes. All right, you want to come up? Sure. Okay. Come on up and state your name and address, and you can speak into the microphone. Yeah, have you been sworn in?
Yes.
Okay.
My
Hi.
name's Edward Gibbet, and I'm the owner of 6820 Rolling Acres Court. One of the problems I have with just the 2-car garage is I have a fully restored 1944 Willys Jeep from World War II.
Nice.
And right now it's taken up with the point where we have to park our cars outside all the time. So it's kind of rough in the wintertime. We also have 2 German Shepherds, and unfortunately in the early spring and late fall, it gets muddy in the backyard, so we're constantly mopping our floor 2 or 3 times a day. So one of the intentions of this addition is to have a dog wash put where they can just come right in the back door, and then I can hose them off and not have to mop 3 or 4 times a day. And I'm retired firefighter for the city of Painesville. I was severely injured in the line of duty 2013. I had caught a chimney basically off a roof, and I have a permanent hip injury that nags me. So the reason we want to put a first floor laundry room on is it's easier for me to carry laundry baskets from the second floor or from the basement up to the second floor to put clothes away. And the same thing with my wife. She's not getting any younger either, and she's got some aches and pains from getting older. So thank you for your consideration.
Looks like it's going to be a nice addition. If we approve it.
So, I'll let you go.
Yeah.
Do we have any more
Did
public
you
speakers?
guys have any questions of him, by the way? Okay. Anybody else that's speaking for or against? All right. With that, I'll close the
Public hearing.
public hearing. Thank you. All right, if there, yeah, I will entertain a motion to approve.
I'll make a motion to approve.
Are we
Second.
gonna have a discussion, or
Yeah.
do we have to do that?
Right.
Okay, gotcha.
Second?
Been a while.
Can I get a second? Okay, all right, discussion? We see this a lot.
Yeah, well, it's a corner lot issue, and
Yep.
for the fact that if Bryan Drive didn't exist, he'd be well within his ability to build
Right.
based on a setback of a side lot, so.
Yeah.
We don't have anything from any neighbors, either for or against. Heather, do you know if we got any emails? either
I did not
support or-
receive any correspondence regarding this.
Okay. Yeah, it's on my bucket list, a dog wash. So it's a third
popular.
garage. It'd be nice. Certainly, it's as far as the hardship goes, it would make his life a little easier to not trudge up and down the stairs so much. And it's my 2 cents.
I'm just trying to think of Duncan factors, and I'm looking at the layout, and I'm trying to figure out if there's, what the alternative could be, if there is an alternative. And I'm like, well, could you build the garage on the back with the driveway going to the side, but then you're adding another driveway, which
Right.
that's a whole nother added cost. So from a hardship cost perspective, like that's not really viable. I think it's it fits in with the house. It's pleasing to the eye. I don't see any issues with that. Will it add value to the neighborhood? I think obviously it will, because you're adding a garage, 3-car garage as opposed to a 2. So I think for those reasons, I'm in favor.
I agree with everything both of you said, and I think it's a very high-quality addition that will add to the neighborhood as well.
Absolutely.
I think a red car garage instead of a car sitting out in the garage is really better for the neighborhood.
Yeah, I don't think it's terribly substantial either. We see this all the time, and consistent with our reasoning in other cases, very similar, if not exactly on point with this. I don't see why this is any different. So. All right.
Do you want to ask how we approve those?
Okay, the chair will now entertain a motion to approve the application for a conditional use variance. Do I have a motion?
We already motioned.
It's already approved.
Oh,
You already did a motion.
okay.
The area variance, you just haven't voted yet.
Heather's gonna call
There's
the
a
vote.
motion and a second, you just haven't voted yet.
Okay, Heather, we'll call a vote?
Okay. Ms.
Thank you,
Garkar?
counsel.
Yes.
Mr. Rowan?
Yes.
Mr. Goling?
Yes.
Mr. Falkowski?
Yes.
Mr. Sweeney?
Yes. All right, thank you very much. Good
Thank
luck.
you very much.
All right, for our second matter tonight, we have another variance application, 2024-152. Martin and Denise Babick are requesting, thank you. Martin and Denise Babick are requesting the following variance for the property located at 7660 Hermitage Road and being permanent parcel 08-A-0-27-0-00-011-0. A use variance from section 1503A1 to allow an accessory building to be constructed and used in violation of the district requirements. B, a use variance from section 15.03A4 to allow an accessory building to be used as living quarters. C, variance from section 1503A6 to allow a 2,560 square foot accessory building in lieu of the maximum 1,532 square feet permitted. And D, variance from section 15.03A8 to allow the square footage of an accessory building to exceed the square footage of the principal building on the lot. All right, you can come forward and make your presentation.
Hi, my name is Christine Moore, 12505 Wooden Road, Chardon. I am here on behalf of my sister-in-law and my brother Martin Babick.
Okay,
I apologize. Have you been sworn in?
Yes, yeah, still here.
yeah.
Yeah. Sorry. Anyhow, we are here, first of all, to apologize and also ask for your forgiveness for starting this apartment, which is only 600 square feet. I'm not sure what I didn't read the whole verbiage here. But we started this apartment without permits, and my parents last year were both on hospice care. My mom was in and out of 3 hospitals. My dad was failing with his Parkinson's. And we got to the point where my dad's like, we're not gonna go in a home. They said, no way, they're gonna go into a facility. And so my dad said to my brother, would you be interested in maybe putting an addition on your house, your barn? And here nor there, my brother says, how about we put it on the barn? And my dad said, it's a great idea. So it's actually a 600 square foot apartment that was put onto the back of his barn. And my parents lived there. They moved in. We were actually in the process of selling their house on Morley Road. And we moved everything out of their house, had barn sales, got rid of everything. Moved them to my brother's house in August. And my dad has since passed away 3 weeks ago. So, and my mom is, still with us, and actually she wants to live her last days there also. So it's been tough on the whole family. It's just been overwhelming, really. So I'm hoping you'll be lenient with us, and please let the variance.
Okay.
Did I miss anything? I'm kind of getting nervous, but telling the truth.
Well,
Do you know
does anybody have any questions?
Yes.
Okay. Let's start with that.
Okay.
There's
Maybe
a
I
lot,
went too
there's a lot
fast.
going on here.
Yes.
Okay. So the first, I guess let's start with I think the harder question. Is your first variance is asking for the building that is currently constructed that was constructed for agricultural use and is not being used for agricultural use, and you were asking for a variance for that.
We're asking, the addition was put on the 600 square foot apartment we did not have permits for. So I'm not sure exactly all the verbiages here, all these, I'm not sure which variance we need to get approved.
So I
So the
think
first variance.
I'm kind of,
Yeah, so the very first variance, when this building, the original barn was built, it was built with setbacks that were more lenient towards the street because it was supposed to be built for agricultural use. After the apartment went on, and that was found, it has been discovered that that original barn is not being used for agricultural use.
okay. I am only here on, regarding the apartment, that we did not get the permits for that addition.
So who's here for keeping the barn then?
so. Let me ask a question.
I guess I'm confused, I'm so sorry.
Let me ask some questions that might maybe help steer this where we're all trying to get to. So the barn was built at some point.
Yes, I couldn't even, my brother, it's my brother's
1955.
property.
1955.
I couldn't even tell you when it was built.
1955.
Okay,
It was built for agriculture.
No,
No.
no.
I'm confused.
The house.
The house was built in 1955.
Oh, the dwelling, okay, my bad.
Yes.
Yeah, there's a house and there's a barn, and the addition of that.
2017, there was a permit pulled for a barn to be used in agricultural purposes.
Okay.
Indicated 1920 square foot and to be used for storing animals, wine, and tractors. Since the property is over 5 acres, the barn was exempt in agricultural improvement, which meant it was not required to conform to zoning setbacks and size requirements.
So piggybacking off of that, so it was originally built for agriculture. What is being stored there now?
Farm equipment.
Farm equipment, tractor.
You have to come up to the podium.
Yeah, and we need to. Were you sworn in?
Oh,
I need to-
she didn't stand up, she didn't stand up.
Well, I just want to, I think I want to address the process here, okay? Normally, the applicant who's most knowledgeable would come up and tell us why it is they have violated zoning codes and why we should give them. So I guess,
Was because I thought it was pertaining to her parents.
Yeah, we thought we were just here
She's
for,
not sworn
So
in.
we need to.
Can we swear
so,
somebody
all
else
right,
in?
so hold, so where's Martin?
he,
He's out.
yeah.
He's out of town.
Yes.
Okay, we need Martin. I should say you need Martin.
Why?
Well, because we're starting off in a very confused
I'm an
state.
owner. I'm the owner too.
Okay, well, that's fine, but it's my understanding that Martin's a builder. Is that true?
Wait,
Okay.
Mr. Chairman, please don't, she's not been sworn in, so if you want to
All
ask the
right.
questions of somebody
All
else
right.
who's not at the podium, you need to have them come up and get sworn in.
Might I make
We
a
should.
suggestion?
Can we swear her in now
Let's just
that
swear in.
swearing in
Yeah,
has
let's
been
get it
done?
off.
All right, let's swear in.
Are we allowed to?
Sure.
Yes. Okay. If the owner of the building would like to speak, if she could get sworn in, however that
We
is.
need to get her to stand up and raise her right hand.
Okay.
Have you been sworn in?
Yeah.
All right, ma'am, you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. So, before, you-
Name,
what is your name and
address.
address, ma'am?
Denise Babick, 7660 Hermitage Road.
Okay. All right, let me just state something, okay, before we go any further. It might be very beneficial for you to have the owner, your husband here, to address some of the more technical things, because he is a builder, and I just think it would be much to your benefit to have him present. Okay, now having said that, you have an opportunity to table this and have him here, so we can address it in a less confused state. But that's up to you. If you want to go forward tonight, that's fine.
I think you're fine, I mean, we're just telling the truth, I mean, this is what, we thought, honestly, we were only here for the
We
addition.
built the barn originally when we bought the house. We raised pigs, we made wine, did all that stuff. We have a Kubota, we have a tractor, that is in the barn. I thought it was about the situation,
Yeah.
we're just, in July, we threw this lean-to up for her parents who were in dire straits.
Yeah,
We don't have setbacks, we sit on 7.5 acres. We're clear back, you can't see us from the road. So I don't know that, I know we didn't violate any setbacks or anything like that. I mean, that was all done to code, I mean, so when we built the barn originally. We're way back on the Interstate 90s on one side of us. The golf course is across the street on the other side, and our next neighbor is probably 500 feet up the road. There's nobody by us, and there's our neighbor that lives way back behind us on the other road. So you don't see us. You can't see us from the road. But when we built that, yes, we had pigs. We had a horse. We had wine. That was done. There's farm equipment and stuff in there.
Do you have any of those now? Pigs, horse, wine?
No, but we do the wine.
But the tractor is,
We have a Kubota,
Right.
yeah, and a dump truck.
and I'm sorry, are you two related?
Yes, this is my sister-in-law. My brother is Marty Babick.
And it's
And-
your,
It's her parents.
My parents.
okay.
So
My
your
parents.
husband's, your in-laws,
Yes.
the owner's in-laws that,
Yes.
Okay.
My husband is Mark Moore, R.L. Moore Builders. He's he's been in building business forever in Concord. Born and raised in Concord. My brother Marty Babick also many years in the construction concrete business. It was done properly. It was just, we were in dire straits. We put it up. My parents were very sick, and we did what we had to do for our parents. And
It's a 20 by 30.
it's just a little one-bedroom, little lean-to off the back of the barn. It's nothing like extravagant. It's just a little teeny apartment for them, where my dad, passed away on April 13th.
Well, ma'am, we understand your exigent, I mean, we're sympathetic to your family situation, all right? But the fact still remains that there were multiple violations of longstanding zoning codes that brought you here tonight. And Martin, who was a builder, should have known this, or at least that's what I would tell him if he were here. And so we were hoping that Martin would show up and give us some sort of explanation as to why all of these violations occurred and why he shouldn't have to conform to the zoning rules just as every other citizen is. So if you can't explain that, we're going to go ahead and vote on it.
Who built
Heather,
that? Who
can
built
you-
the addition?
My
I was gonna say, Heather,
husband,
can you give us a little bit more clarification of maybe what you saw, the other inspector saw of, than where, so in my opinion right now what I'm looking at is A, C, and D, the variants A, C, and D are referring to the existing barn. The variance B is for the apartment that they believe is the only thing they're coming here to talk about. So can you give some clarification on A, C, and D of how that
Sure.
Application
Yeah,
came
sure. I've been
about
sworn in.
this.
I've been sworn in. So I'm acting in my zoning inspector capacity at this moment. So I can give some background to how we got to today. As stated previously, the barn was originally approved as an agricultural use. A permit application was submitted by Denise Babick on April 4th, 2017, shortly before they owned the property. I issued it as an exempt agricultural building based on the fact that the application indicated that wine, tractor storage, and animals would be utilized in that facility. So with any agricultural use, we issue that exemption and they do not have to conform with zoning. In this particular case, the size of the building exceeded what would be permitted if it was not a non-agricultural use building.
Okay.
Fast forward to February of 2024, was brought to my attention that some kind of addition was placed onto this barn. I could see it from I-90. I could see it from Hermitage Road. I sent Mr. Babick a letter on February 21st, 2024, inquiring about the addition to see what was going on, if it was related to the agricultural use. Mr. Babick subsequently called me and admitted that he had put a living area onto the back of the barn for his parents to reside in, and was very open to coming in and applying for whatever permits he thought were going to be required. And at that point, he did submit a zoning permit application, which you have in your packets here, which I reviewed in compliance with all of the R1 district standards. And based on my review, I issued a denial, which as an addendum to that denial, I provided a letter to Mr. Babick outlining all of the detailed sections of the resolution that it was not in compliance with. And subsequently, he filed the variance application for all 4 of those non-compliant sections to keep the structure that is there now. And during that zoning permit application process, on the permit, you should have it here.
Take your time.
Looking for it.
That's what I thought it was for too, just the addition. I don't know.
There's so many papers here. Bear with me here a second. Okay. Yeah, so if you look at the denied zoning permit application number 0324-2732, his project was submitted. The plans that were filed with me included the barn plus the addition. And on the layout plan, and after conversing with Mr. Babick, he admitted that the wine area was not there, nor the animals, the bedding area, and that he was, and the side door that was initially shown on the layout plan for the original barn was never constructed, and indicated to me that at this time they didn't have any agricultural uses present, and they were using the barn for storage. And so in my opinion, that was where the use of that building was no longer for agriculture. It's more of a storage building with the in-law suite, and that is the basis of basically my denial.
So I also think I made a statement earlier that said setbacks, and it seems like that is not a problem, and I misspoke. It is all in square footage,
Yes,
not setbacks.
square footage and use, and not permitting
Not-
living
okay.
quarters, and also the fact that this building now is larger than
Their
the
house.
living area of the existing single-family dwelling on the home, which is also a violation.
Okay. And then also looking at the numbers, I think one of you two made a statement of 600 square foot, not understanding where this big number came from. Big number came from the original barn is 1920.
Gotcha. Yeah, it's
you add
very-
your 600, you get the 2520, which is larger than
So-
the house.
So, if I can ask a question, Heather. So to summarize, it was an agriculture building of 1,900 square feet. An addition was added of about 600 square feet or so, so we're at 2,500 square feet. So now, because it's no longer agriculture, it's considered a dwelling, which makes it 2,500 square foot dwelling.
It's bigger than the current one on the property.
Bigger than, and that changes the lot, or the, it changes everything because it's no longer agriculture. It's an accessory building, but then it's also now become a dwelling
With living quarters
with
in
living
there.
quarters.
So it's made it come
And that's,
dwelling.
and that's why.
That's
it's
why
not
the square
just-
footage was so much
That's why
on
this,
that variance. I gotcha.
Okay.
Yeah. It's, they're adding the.
And so to check my understanding, Heather, if they had built the in-law suite not attached to the barn but attached to the house, everything would be copacetic. More or less.
Yes,
pending approvals.
yes.
But
Pending
because-
upon,
Yeah,
submitting the
pending.
proper zoning permits and building permits and all
But
of that.
providing it's attached to the barn now, it changes the barn's status. And because the barn is.
And also based on the information that the property owner,
Right.
Mr. Babick, provided
And
to me.
admission is no longer being used for agriculture, although it is being used for storage, and now it has the residential component attached to it, then the square footage then comes into play because it's no longer falls under the agricultural exemption.
Exactly.
And did I also,
Now I
Heather, there was a couple statements, including today of a dump truck. What kind of truck? I want to.
There's like the dump truck that was in there and.
A dump truck.
Two Kubotas.
I apologize. What are Kubota?
Tractor.
Thank you. Thank you.
One's an excavator and the other one's like a yard utility vehicle.
They're
You know,
cool.
that had like a dump, has a dump. on
So
it.
that's more construction equipment over farm equipment.
No,
It could
well,
be farm.
It could be fun. Okay. But so there's also, I think I read in here, and so please correct me if I read something wrong, Heather, as well as you guys, but I think the Heather reading. There's some concerns that there is construction business use storage in this build. This barn is being used for the construction business. Storage of construction items. Because you guys own a construction company.
My husband actually was R.L. Moore Builders from Concord. He did all the drawings and everything. My brother is also in construction. He does mostly the concrete construction, but he does do construction. And there, between the two of them and my dad, They built
And
the
this is a
addition. They built the,
family-owned, no, this is a family-owned business that does
yes,
construction.
yes, mine
And that
separately. They have their own.
construction company's registered
Concrete.
address is this 7-acre lot. And then this accessory, or this barn, whatever it is right now, is currently storing some of the construction business equipment.
There's two different businesses. My husband was R.L. Moore Builders from Concord.
Okay,
He does not, we don't live at that property.
okay.
My brother and my husband did the project together with my dad. So
I'm asking
is
about,
that,
About Marty's business?
there's a construction business that is registered at the 7-acre
That's where
property.
we- yeah.
okay, that's his, their, okay, that's the
Okay, that's
address.
what I mean by that. Some of that construction business, vehicles,
truck?
vehicles are being stored in the barn. Is that a correct statement?
Sure,
Okay.
yeah. If they're not on a job, yeah, they're at home.
Okay. So I think that was one of
Yeah.
Work
the
trucks into it
variances
and
that got
come from
brought
the
up.
It's just a work, yeah, there's this workshop, yeah. Then we have 3 other, my son's at home, so we have 4 other vehicles at home too, and a boat.
Okay. Had there something in the staff report about construction business items being in the barn?
There was a concern that there could have been construction items stored in the barn, yes, because you can see them on the property when you're driving by.
No, you can't, we're up on a hill.
You can see it on I-90 when there's no trees on the leaves. No
Okay.
leaves on the trees.
That's
Yeah.
Okay.
I drive a school bus and I don't even see it when I drive by from Shelby, so.
Here nor there.
So how did you get around the water
I thought we
sewer?
were just talking
Ma'am,
about
ma'am,
the.
how did you get around the water, sewer, and electric hookup? Didn't the county get involved with
No,
that?
he has an electrician.
Right, so he just basically
It's a really,
so he can, your husband connected with county utilities.
The barn,
there's a barn there.
it's
That
connected to the barn.
I have a picture if you'd like
Did
to
the
see it.
barn
It's
already have
Okay.
electricity
Okay.
and water in it when you originally built
I
it in
can show you a picture if
2017?
you'd like.
So you guys just tapped into
off the back
exist.
of the barn.
Yeah, it has
Right.
water,
Hold on.
sewer,
Man
and
door that
gas.
goes
All right,
into
one at a time, please.
The
One at a
barn
time.
has water, sewer, and gas.
Already,
We
so
just
you-
tapped into the barn.
Okay.
Okay.
So it was constructed in 2000, water, gas, all this stuff needed.
Yeah, Tim Smith and.
Constructed in 2017 with
Okay.
the county. So you didn't, okay.
It was all done properly, trust me.
It was all done.
But the Moores and the Babicks, we can pretty much do anything. Except we did not get permits because we are in dire straits with my parents being so ill. And we're just here to hopefully take care of it.
Well, do you see what kind of position it puts us in as
Yes.
the board to enforce these zoning rules? When
I
you just go
understand.
ahead and do whatever you want?
I understand. I apologize.
And then you come back to us, and it puts us in a very, very uncomfortable position because I totally relate, or I sympathize with the health issues in your family that you've spoken about, and that's terrible, you know. But that's not our job is to look at the violations and rule on them. And I'm not seeing any argument that was presented to justify us allowing this to continue. You see what I'm saying?
Is the living quarters complete?
They're in
Yes.
it, they've been in it since.
So
Yes.
they're living in it. Like it's complete.
I want to say it was.
Is
I want to say they got in there in August. I don't have the exact date.
What is the tax status of this 7-acre property right now? Is it agriculture?
No,
It's not. So
It's
if I look it up
residential?
right now, it's going to give
I
you
don't
a
have
residential
the
tax
it's gonna give
status.
you residential taxes.
It's
yes, sir.
R1.
It's a R1. Okay. I mean, if that's what you represent, that's fine.
I have to be honest with you. Reading all these variance sections, I am so don't really totally understand them.
Sure.
So
I'm going to ask
There's
you
so
a
many-
question.
I understand what you're saying, Skip, because with the knowledge of the construction industry too, that's also making me struggle even more with this one.
Yeah. There's a lot of hurdles you're asking us to either jump over or ignore.
I'm sorry.
No, you're fine. I have a legal question. If you could clarify, if I almost see two options. And legally speaking, it's we approve it, let it all go, or we deny it and we force them to tear down the barn and living quarters. What are? Is
Those
there
are
more options
generally-
than that?
No, I mean, those are generally options. You could also approve it with certain conditions. You could, give a timeline for how long the living quarters can stay. And there's other options. But yes, this is a use variance, and then there's also area variances. So even though it's convoluted and kind of confusing, but your options are the same as any other case.
Okay. And I think Skip had asked this earlier. If the living quarters were attached to the house, this would not be an issue.
Probably not.
That wasn't an option.
You said it's a lean-to? It sounds like it's,
It wasn't an
Kind
option
of-
to put it on the house because Dad couldn't go up. There would be
No
too
steps.
many ramps and
Could-
steps.
it'd be-
so is
like
it
being
insulated?
put
What is
there.
it?
Yeah, it's a one-bedroom apartment.
You should come see
Okay.
it. It's really nice.
I can show you a picture if you'd like me to. I mean,
Yeah,
It's so that
I'm
they
down.
can-
I'd like to see
If
it.
you have
Yeah,
it,
actually, then he could pull in the barn, we pull in the barn, and they can come out the back door and get in the cars out of the weather and just work out.
let me try and find the.
As they're
I'll find
looking
it
for
quick.
pictures,
There's a lot of pictures here.
Well, I think let's wait till she's done talking. Go ahead.
I know it's probably hard to.
How's mom doing?
She's doing okay. And her mother also has Parkinson's, and she's got hospice. It's just been a disaster.
have a suggestion of moving forward. Do you believe there's more information needed?
That's definitely the role of the board. If you guys feel there's more information needed, you should definitely seek it out. You can
Yeah, yeah.
I don't
Sure,
mind.
sure.
Then you.
I'm up in the.
Okay,
I mean,
so
Heather's here, she definitely has a
So,
lot of information
this
she
is what it looks
provided.
like. That's it.
Okay.
There's my
Great
dad,
history.
and that's
If you
the
have
barn
additional
there.
questions
and
that can't be
Route 90's
answered by
over
the
here.
appellant,
Yeah, swipe over. Are there
feel
more?
free to move
Oh,
to
yeah.
postpone to bring it
That's
back.
it. It's really just
Do you have
So
what
that
it looks
would-
like done?
Be something very
Uh,
acceptable.
I
of
I
asking
don't.
to
I don't know. I'd have to
postpone
really
until
search through my pictures, but
what
that's my
seems
dad's
like the two
supervising. Yeah.
husbands.
Got it.
The
See,
two
like, maybe
construction
it's like a
people
Got
are
it. I see.
Whatever
potentially able
Just-
to talk
and
more if they
whatever
have more
more
If you
information.
think that information,
Change.
Yeah.
if you think that information is necessary to make a decision.
Do you guys want to see the pictures of the lean-to? It's the construction pictures, not the.
it doesn't matter to me.
Okay.
I'm okay.
All right, I think we're good.
So, Brady, am I to assume that if we deny the use variances, that the other variances fall away?
I don't think so.
Okay,
Because you could still approve the area variance on the square footage of the accessory building.
right, I see.
I don't think it's in the alternative. I think they're all separate.
Okay.
I'm just wondering myself. We should have brought an attorney with us. I don't really understand all the verbiage and all of that. And I thought we were going to come in here.
Well, as it
understand.
stands now, the presentation that was given doesn't make clear to me exactly why we should allow you to continue doing something that no other resident would be allowed to even start to do. Do you follow what I'm saying?
Yes.
In other words, what you're doing is you're coming here and you're asking, I mean, with all due respect, you're asking for forgiveness for something that you've already done. I wish your husband was here because I would have many questions for him regarding his knowledge of what it is that you need to do before you do things like you did. Okay? And as a builder, he would be number one on my list for a person who should know these things. And it sounds to me like he just didn't bother to do them. I
Well, it's just
understand
like
you
I
had some
said-
time constraints. I get it. But I just wish he were here. And because he's not here, it may not answer my questions substantially enough for me to grant these. So, again, if you want to table this, Heather, do they still have the opportunity to do that at this point?
Of course, and
Okay.
you can also, if you guys need more information, you certainly are allowed to postpone
I would
it.
like to talk to your husband,
Okay.
Is-
My
Okay.
husband or my brother?
Who, fi-
Whoever built it.
whoever built
They
it,
both did.
or then
who
both of
filed
them.
the
Yeah.
variances?
They did.
Your husband.
Me or Marty? Marty.
Yeah.
This is. There's two of you, and both husbands did it.
Isn't that how it always?
It was teamwork. They were, boom, get it done.
Who filed the variances?
I think
The
Marty did. Me and Marty.
Both Martin and Denise Babbitt's names are on the application. Looks like according to the auditor, just Martin Babbitt is the actual property owner.
okay.
Do you understand?
Actually, we just put it in a trust.
Do you understand the options you have here?
Well, I'm hoping we don't have to tear it down.
Well, we're not even at that point yet, because my questions haven't been, I mean, I can't even begin. I would ask you, but I don't know that you have the answers. No offense, but, so I need the people who did this here.
Okay.
But if you would like us to move forward as is, we can do that. It's up to you.
What's it do?
Or we can move the table
I
as
was
well.
gonna say
which I
I-
think we should.
Well,
probably-
I don't know, because that doesn't mean he's gonna show up next time. They have to represent to us.
I just don't know if he's gonna give you any different answers than what we're giving you. We're telling you the absolute truth of what happened, and
I guess we have to get an attorney. I don't know.
I just didn't think it was gonna be this stuff at all.
I guess we could just table it then. Just talk to our attorney.
I mean,
I guess we're gonna have to go a different route.
do we have any
Have them
hope
come
here
in.
or no?
I think that might be
Okay.
wise,
Okay.
just to give you the best chance.
Okay.
To table until all parties are able to table till next meeting,
Next meeting.
for all parties.
When is that?
To be present, to answer both parties that built it to be present to answer the proper questions. Is that what?
That's what I'm saying. I just don't think there's gonna be
You're
any
asking
other
for?
answers.
Well,
that
you
are
need
gonna
to
be such a
represent
clear-
to us that you would like this tabled, meaning put on hold, and that you also need to represent to us that you're going to return with Martin, who was the owner and co-applicant, and then the other individual who helped build it. Who's that?
My husband,
Okay, what's his name?
Mark Moore.
Okay. Can you do that?
Yeah.
Is that okay with you guys?
I'm hoping, but I just don't see how it's gonna
I
make.
mean, I don't see why they wouldn't want to be
Oh,
here.
no, I'm just saying.
No,
I'm
he
just.
got called out of town on business, believe me, he would have
Okay.
been
So
here.
I'm just
That's fine.
depending on when the next meeting might be, or there's not gonna be any other different answers than what we're giving you. That's why
That's why
I
you
can't
gotta-
understand.
That's why you got a bus driver standing up here. That's all.
Well, I don't know that they would feel the same way if you told them what happened tonight.
Okay.
Okay?
The next meeting is June 12th.
Oh, we'll be, no, we won't. What's after that one?
That I don't know. Is it the second Wednesday?
Second Wednesday of every month.
Second Wednesday of every month, then we'll do June.
So
June's out.
is that too long? How, I mean, do we have a limit on tabling?
They're asking for the postponement for another 60 days. I mean, you guys can certainly approve that.
Okay?
So I guess the question is to you, do you, we need you to request to table it, and do you need 30 days and then come back and potentially table it again?
Or 60 days.
Or 60
days
days?
would be perfect.
Yes.
We already have it scheduled out.
2
of the-
months.
we'll be out
Okay.
on the 12th. We can do it.
Given all of these variances that are up here, Heather, as zoning inspector hat, do you have any suggestions of, is 60 days, do you think that, I mean, obviously it's everyone's right to ask for 60 days and us to approve or deny it, but do you have any suggestions of something that should be on it to make sure this doesn't get dragged out for multiple times to get this taken care of in an
Oh, no,
appropriate
it'll
manner?
get taken care of.
It's up to, I don't know if Brady needs to chime in on this, but I think it's at your board's
in your
discretion
court.
as far as what you think is acceptable as far as a continuance.
I
I
would
just want to
recommend-
point out that the July meeting is July 10th,
Mhm.
so that might be more than 60 days, just
Yeah,
Is
I would
what-
say 2
yeah,
months,
just-
not 60
okay.
Or
days.
this, 2 meetings from now.
Yeah, not 60 days.
And I would say that at that point, then we can reevaluate if things change, or if, we can say, okay, we're gonna vote on this now, or we're not gonna table, we can vote to not table it. Or depending on situations, we can table it again further, but I think for now we do 2 meetings from now,
Okay.
July meeting. We can probably just say the
What am I gonna learn 60 days from now that I don't already know right now?
See, that was my question.
I don't know.
Facts? What are the facts?
Facts
that we're
are-
looking to learn?
Forgiveness versus permission. The place was built in an emergency, to their point, without permits, without permission. It's illegal. It can't be there. The barn is bigger than the house with the addition now on it. The barn's no longer being used as agricultural, and it's being used for business storage. Mom needs a place to live, on the other hand, right? And they're in dire straits. So now we've got 4 things on our 4 variances that are requested that I know everything I need to know. There's a lot of things that they did, granted in an emergency, but to that end, the builder knows better.
And can I ask, and I don't know if this is, Heather, do you have anything to add that we need to be aware of? Or?
No.
Okay.
I don't know that having the builder here is going to teach me anything.
All right, well, that's not really the point. The point is, do they want the opportunity to table this for 60 days
But we still have to
in
vote on
order
it.
to
Table it.
supplement their arguments and presentation?
Even
you
if
can
they
do that
ask
or not.
for a table, that doesn't mean we grant the tabling, though.
Well, since I brought it up, it's probably going to be granted.
Table it and just talk to the guys. I can't handle much more. I really can't. I'm gonna have neighbors breakdowns. I know. I just really don't.
Just make your ruling tonight, it'd be great.
All right.
Greatly appreciated.
I'm sorry to add confusion to this and upset. I really
No,
am.
that's not your problem.
All right, well then, if there's no other questions,
Could I ask you one question before we
Yes.
give your answer? So once you give your answer, yes, no, there's no going back to come back before you again.
I don't think so. No.
You know,
I mean, it's not our application, it's yours.
Yep.
You have to decide.
I say we table it
No,
until.
I just want to be done with it, Chris, just done. Just go ahead and vote, we'll handle it, do with it.
It's your property.
Yeah, we'll just deal
We
with it.
just gave you the honest truth about everything, so I hope.
Yeah,
Understand?
Do we have any more questions for the applicants?
No.
I do not.
Brian?
No,
Okay.
David?
I don't.
Okay. All right, thank you. Is there anyone else here speaking for or against these applications? Anybody else speaking for or against the applications?
Saying no.
All right, if not, we'll close the public meeting. All right, discussion. Well, first, can I get a?
I'll make a motion to approve all 4 A, B, C, D
Yeah,
variances
okay,
that are on the agenda.
so moved. Second,
But you made a motion to what?
I'm sorry.
motion to approve.
Yeah, Ms. Garker, if you could at least read off the variance application number in full.
We just table it.
We just closed.
We've already closed.
I apologize, Heather.
I was just gonna say, when you make your motion, to please read a little bit
All
more
of
of what
it.
the agenda item is.
All right, so we
Let me
just.
apologize. Let me go back and
Friday,
read
so
that number.
we just got a request, so I'm gonna reopen this. Ma'am, could you approach the microphone?
And,
I'm gonna.
Okay. So just take the
I think we
motion
should
back.
table it.
Okay, all right. We'll do
I think
that.
there's too
didn't
much
make the
emotions
motion
going
yet. I
on
did
here.
not make
and-
the motion
Understand.
yet.
But do we need
Just
the
too
property,
much.
do we need the property owner to make the request?
Well, ma'am,
But also, do we need to reopen public hearing?
I just did.
can I take
Okay.
it, please?
Her mother also is sick. Not
Okay.
too good. Brings out the big Beth, our fan.
I know, but you, but please understand our situation here. Okay.
I'm sorry.
All right, so there has been a request to table this matter for 2 months, and
To the meeting in July.
to the July meeting. So that will be continued, and
We have to vote on the table.
You have to make a motion and a second and a vote.
They
whether or not you
requested
want
it,
to
so we
table
still
it.
have to make a motion to table.
okay, so the motion is to table the matter till the July meeting.
Second,
Do I have a motion for that?
I move to table the matter
Okay,
to the
second.
July meeting.
Second? Somebody give me a second.
You can second, I made the motion.
All right, second. All right, let's take a vote. Heather?
Okay, Mr. Sweeney?
Yes?
What are we
Mr.
voting?
Goling?
To table.
In favor of tabling or not?
No.
Okay?
Ms. Garkar?
No.
Mr. Owan?
Yes.
Mr. Falkowski?
No.
All right, so that motion does not pass. Now, do I have a motion to approve the use variances and variances applied for A through D?
So we move to approve, but we're gonna discuss and then vote, correct?
Right.
I will make a
Before
motion.
you move for that, can
Yeah.
you separate at least the use variances versus the area variances, since the discussion will be different?
Okay, let's do
Many
that.
factors.
Yeah, all right, so do I have a motion to approve the 2 use variances, A and B?
I will make a motion to approve variance application 2024-152 by Martin and Denise Babcock for the property of 7660 Hermitage Road.
Right, A
Item
and B.
A and B.
Yeah. Do I have a
So the
motion?
use variance, I'm making a motion.
All right,
So
do I
the
have a
use
second?
variance,
Second.
All right, discussion.
So I'm gonna touch base on to allow an accessory building to be used as living quarters as part, for A and B. That's what I'm focusing on first. Is it? I know you said, Brian, you said we could put conditions on our approval. Could we do something like, a 2-year, and then they'd have to come back, or let's say their mother unfortunately passes away. After that, then at that point it would have to be torn down. Can we put conditions like that on?
You can, however,
Okay,
the applicant has to agree.
so we would have to ask and
those
then,
conditions.
okay.
okay, so we
So-
can discuss this
We can discuss it.
and potentially, to an extent, agree and then reopen up public forum to ask to make sure the applicant agrees?
You don't have to worry about the format
we
as
can
far as
just-
the procedure of the open and the close of the public hearing. You
Okay.
can simply ask.
Okay,
Okay.
so we can discuss it and then ask
Correct.
if they would approve or agree or not.
That's correct.
And so,
Okay.
in that vein, if we were to go down that route, I think one other thing I would look at is also, making sure that any necessary county approvals are obtained.
That's correct, yes. And again, they'd have to agree to that, but yes.
If they agree to, I think, gives compassion to this, but also says that at some point it has to be torn down. And I'm just, at this point, I'm only looking at the accessory or the dwelling side of it. And
Not the
right-
whole barn.
Just right now, not the whole
Yeah.
barn. That would be a whole nother
Right.
thing to look at that time.
So
Again.
the idea is mom can live out her days, and then when mom is no longer there, then we require to be brought back into full compliance with this.
For the living quarters.
The living quarters, yeah.
At least
We still have to
at a
address the
minimum.
barn situation.
Right.
2 different situations we're
Well,
addressing, correct?
I think in order to accommodate the living quarters, we have to approve everything with conditions, because we can't tear the barn down and leave the living quarters.
No, but you can ask the barn to be put back up to the original reason they were allowed to have that large of a barn. You can ask that to be put,
Right, and
But,
so
like,
that,
not-
so that would be, I
not
think,
having business items in the barn and operating storing business items in the barn while mother is living there.
Sorry, I didn't follow that. I apologize.
Sorry.
I think, go ahead.
We can ask if the living quarters with conditional uses or
Conditional approvals.
conditional approvals stays. We can ask the barn side of it be brought back up to use correctly. So it just so happens these two buildings are connected.
Okay, so the barn usage originally was for agricultural, so it's exempt. Are you saying to bring it back to agricultural use? Or are you saying that it has to now comply with an accessory structure as far as square footage?
I'm saying bring it back up to agricultural use of proving that construction business vehicles are not being stored in there and it is being used for agricultural use. Then the living quarters stays as living quarters until not needed. Like separated almost
I
as two
see
different
what you're
buildings.
saying. You can do that.
Once the living quarters is gone, doesn't the barn revert back to just a barn?
Right.
Because then if we, even though technically it is one building, when you look aerial, it is one building.
Right.
For this purpose, we split it up in two separate buildings. We have the living quarters and the barn. If the barn is brought back up to code and being used as agricultural purposes, the square footage is not an issue. There's a lot of things that are no longer
And this
issues.
this is after we like if they were to
So if
agree
we
to our conditions. and
agree to
tear
our
it down.
conditions that the barn is used for agricultural uses only, and prove that that only being used for agricultural uses, which is what made this all exempt in the first place, then the living quarters can stay until mother-in-law no longer needs it.
Isn't the issue with that they're not using it for agricultural use though?
Half the barn is not being used for agricultural use. Correct. So if they can prove that that barn is being used for agricultural use and get the construction stuff out, then the living quarters until mom. So it's then the barn doesn't need to be torn down. Is what I'm. If you show that you're using it for agriculture, then the barn doesn't need to be torn down.
We're not talking
The square
about
footage
tearing-
doesn't matter.
We're not talking about tearing the barn down and leaving the dwelling. We're talking about whatever conditions we put on is temporary. Once that condition is met, then at a minimum, the living quarters would have to be torn down, and then we would have to. Then it would be reevaluated as, is this an agricultural building? And if it is, then we're good. If it's not, they need to come back and get the additional variances for the square footage, and we can make that all part of the condition. Is that when that time comes, and if we need to, and I don't know, Brady, if we say, every 2 years we're going to check, or I don't know how that process works with this condition, because we don't want to say, we want to make sure that it's followed through.
Sure, of course. You
So,
can do that as well. Periodic review, inspection by the zoning inspector within a certain amount of time.
Yeah.
I think my biggest concern with reading this staff report, and one of the concerns, was the fact that the barn seemed to not be being used
As agriculture.
as agricultural. So if we fix the barn and agricultural, we can have a conditional for part A, which is the living quarters, with a timeline.
All right, so as you know, I like to talk things out. So much for me, sometimes for you guys too, so I can all understand this. So we make sure that the barn is being used as a barn and not to store construction equipment. So
For the business on the property.
for the business on the property,
That's
right?
receiving mail on the
It
property.
can put tractors, it can have Kubotas in it, anything to work the land that's there. While that is straight, mom has 600 square feet of her own little place, treading water until the time comes. When that happens, the 600 square feet shall no longer exist.
No longer exist, or just not an apartment. I mean,
It's
it's
too big. It's gotta go.
completely gotta go.
The 600 square feet has to go, but the condition is mom can stay there until mom doesn't need to stay there anymore. Does that make sense?
It does, but countering back to that, because it's being used as agricultural, there is no limit of square footage. So
But it's not being used as agricultural.
technically, when we say it can no longer be a living section, they can just knock out that one wall and just add a blank 600 square foot addition to the barn, though. We're not saying like the outside structure has to be done as long as all of it becomes agricultural.
But I don't think there's a cap for that though.
That would be up to them when they come back and mom is not using the facilities.
Right.
Whether they completely tear down or they take that 600 and make it agricultural, that's up to them.
Given the fact we're dealing with a forgiveness versus permission thing, I would want it reverted. That's my feeling on it. After mom's done with it, I think it's fair that mom should have the benefit of staying where she is until her days, glory days, right? She can stay there as long as she needs. When mom no longer needs it, gone. Put it back. Because forgiveness versus permission. There's a lot of things we're being asked to deal with here.
Mm-hmm.
And I think that we should approach this with a little bit of compassion and empathy, which I think we are. But also knowing that the zoning code exists for a reason and that we just can't shack stuff together and pray no one sees it.
I completely agree with that statement. And I do believe that is, as of right now with our discussion, a big thing is putting whatever it is, 1,900 square foot barn back into agricultural use and not using it as a business storage.
Right.
So, but again, if they chose to not go back to agricultural use, they would have to come back and get new variances. Because what we're doing right now is we're essentially approving it on a temporary basis for the mom to be able to use it until she no longer needs it. After that point, everything's back on the table. It has to be torn down. It has to be reapproved if they want to use it for something other than. I mean, that's what we're putting in the condition. Is that
Well, no, if they
dwelling-
continue, if they would switch to the 1,900 to agricultural only and prove to the zoning inspector that it is only agricultural use in the barn.
Right. At that point,
And
they
then
wouldn't have to do
when
anything.
right, and so that
What I'm
1920
saying is-
stays forever. There's no variances
At the end
needed
of
at
it,
the end.
we can say in here that the zoning inspector, there's going to be, let's say, a yearly check-in. After that, let's say at one point, okay, now we need to revert back. We tear the dwelling has to be torn down, and if it's not being used for agriculture, if it's being used for agriculture, you're fine. It's torn down. We're done. Assuming all zoning regulations are met for that use. If it's not being used for agriculture, then they would have to come back in for that variance.
Or something else.
And so I guess the question is, if we're approving it with these conditions, we're not actually approving anything that says like, okay, if they tear it down, this is still approved. These approvals have like an expiration date.
Correct.
So does that make sense to everybody?
It does, but I do have a legal question or a other question. I don't know. Is it possible within what we are able to do an inspection to make sure that it is agriculture use?
Absolutely.
Yes.
Absolutely.
Okay. Just want to make sure we're not approving something that Concord cannot do. Okay.
So I'm going to ask a question then. So is there any more discussion or because what I'd like to do is been kind of taking notes on what the conditions are and like maybe I'll read these back and we get them in a way worded how we would like them, ask the applicant if they agree to them, and then we can move forward. Does that work for everybody?
Yes, I want to make sure legal's agreeing the way we phrase
Exactly,
it, that it's
yeah, I
done
agree.
correctly.
So like
But
what I have so
yes.
far is the first condition would be getting county permits, getting any necessary county permits that aren't there. A yearly check-in with the zoning inspector so that Heather will check yearly. Is it still being used? If not, then everything kicks in to tear it down. The expiration is when your mother no longer uses it. And I assume we will want to get her name in the record as who that is. And then once the dwelling is torn down, it reverts back to agricultural use, and which meets the original application, if it's not being used for agriculture, then all of these variances would have to be filed.
When you say dwelling, you mean the living
The living
quarters
quarters,
on
living
the
quarters.
accessory. Sorry, I'm just fine.
No, that's good.
I get the permits thing, but that's not our bag. I mean, we can't require them to get permits.
Can we require them to get county permits?
We can.
Yeah.
Okay, so just to clarify, phrase a little different. Mom can live there. County permits have to be pulled. I'm making sure that all this stuff, like, we can't ask of this. County permits can be pulled. Barn goes back to agricultural use. So we would have to figure out in the next 30 days, prove that it's agricultural use. Probably.
I mean, that would be the zoning inspector inspecting at her leisure. So that'd be up to her when she
Right.
inspects.
If we can, I don't know if an inspection can, 30, 60 days, whatever.
Whenever she wants.
Do you have a preference on any?
I'm totally lost on what you're talking about me going and inspecting, to be honest.
Well, not. I think so. I think what we're looking for is that we would need to check in with them to say, like, is this still being used? How often would we want to check in? 6 months? A year?
I'm not.
What's?
I think just a one-time proving, like, hey, this is agricultural. Let us come in to show that the
So once-
barn is being used as agricultural use and not being used as a business property. Then mom can stay there.
It would probably tie into the inspection of the living quarters being removed at some
Right.
point, I would think.
The
It
living
would
quarters have
tie
to be
in
removed, and that's when you would.
To what is the use of the accessory building? Is it for agriculture or is it for personal? Which I guess kind of could be. So.
I thought everything would just tread water until mom doesn't need it. Then
Everything
and then
kicks in.
Okay.
it's hammer time. So until then, I mean, right now it's I think the compassionate thing is let mom stay there. But when mom doesn't need to stay there, then the rest of this has got to be strict rules brought back in.
So you're saying there's no concern for currently operating a business in the barn?
I mean, is the guy parking his construction truck in
Operate
there?
business.
I don't know.
say that loosely.
Maybe, I don't know. But is that going to change the fact that mom needs a place to live right now, temporarily? No.
Okay.
And so, I mean, again, I wish he were here so we could address this with him too. But you know, we got the ladies here who are equally as able to convey the message that you can't use the private lot for construction stuff. The barn's got to stay for the Kubota and hay, maybe some goats. Who knows? I'm pretty adept at chickens. If you were here at the last meeting, and then mom stays there until mom's gone. Then, when that happens, we get notified. We readdress the variances here, and we have to bring those into compliance. That was my thinking on this.
It seems more simple than what I was expressing.
You know,
Sorry.
I think you guys, number one, need to make a motion and need to state your terms. okay?
No, I agree.
Right.
Well, we have to
Right.
make sure that the
Right.
applicant agrees.
Go
to
ahead and
it
do that.
first.
But I'm very concerned about the precedent. See, when I look at this, when I look at the staff report, when I look at the analysis of the violations that are asserted here, violations, plural, nowhere in the standards of review does it say, oh, if there is a sympathetic plea that is made by the family, then you may alter your application of the standards and do whatever you want to do. Okay? I understand the situation. I get it. I'm as compassionate as the next guy, but I'm concerned that because we're doing this, it's going to set a precedent that if someone else comes in here and does, well, first of all, someone else does something without asking us and comes in and asks for forgiveness, all they're going to have to do is say, well, you know what? My aunt was ill and I had to make that addition 5 feet from the setback instead of 50 feet. I had to do that. That's a dangerous precedent.
What's the point of
I
this
just-
board if we don't look at things on a case-by-case basis?
Well, we are looking at things
No,
on a
I'm
case
saying
by case.
though, but if
But the only
everybody
reason
followed the rules,
but
we
the
wouldn't
only
need a board.
reason I see that you guys are moved to doing this is because of a sympathetic plea. There's been no. This is why I wanted it to be tabled, so that it could come in and there could be a cogent argument made as to why we should grant the variance in addition to maybe a sympathetic plea. But that wasn't done, so I'm concerned about it.
I don't think it changes anything.
All right, well then make your motion.
All right,
Make the motion.
Then I will ask the applicant, do you agree to the conditions of, in order for us to pass these variances on a temporary, essentially a temporary basis, that you will get county permits? There will be a check-in with the zoning inspector every,
I think we need to discuss the checking in with the zoning inspector, because I think there's some confusion of how often and what they're inspecting.
we just want to know if the tenant is still in the, not dwelling, the living quarters.
Correct.
I'm
so
just
how
going
are
to
we
make a
supposed-
very blunt statement here. From my understanding, she's staying there until she dies.
That's what we said. But is that 10 years from now? Do we need to reevaluate? Because, I guess we're just giving it, it's incumbent on them telling us or us checking records. This way, there's a constant, we're going to make sure this is done, and then the follow-up happens relatively quickly, as opposed to it taking years for us to figure it out. And I guess I will defer, Heather, how often do you want to check, or do you want to check?
I mean, I think I would put it on, if you were going to do something related to the time where they don't need it anymore, maybe within a certain amount of time of that person passing, that they shall notify the township officially of that and come into compliance with removal of the dwelling unit completely, that area of the building, if that's what you want to do, within a certain amount of days of that event happening.
Okay, that's
I
fair.
think, really needs to be tight and very clear so everyone understands
Well, and that's-
what you're asking for.
I would say I'm fine with 90 days.
But
So-
my other concern would be if, what if the property sells?
Well, I
This
think
is not a
No.
grandfathered in situation.
if the property sells, then I think we say that,
Still applies to
everything-
future owners?
well,
No,
No,
because
I
it would be
just-
applied to just one
we're putting a
person.
condition on there.
Right.
Isn't the condition for one singular person?
You would have to ask the property owner to agree to that, in other words, so that it does
Right.
not carry with the land if in fact it gets sold or transferred.
Okay. Okay, so get county permits. 90 days after tenant is no longer there, would notify the township zoning. At which point, they would have to tear down the living
600
quarters.
square foot.
Do we want to put a time limit on that within within another? I know this is getting complicated, but I want to make sure
It
that
is
we
very complicated.
get everything in here.
What if you just say 90 days within the passing, that all of that has to be?
Okay, that's fair.
Yeah.
I mean,
Yeah.
It has
Yeah.
to be taken care of
So
within
every-
90 days
90 days
of
of
Okay.
passing.
of-
This is for one particular person, and it is not connected to a grandfathered in of the property. This is for one person who's
Does not-
currently living there.
Okay.
This is
all right.
not grandfathered in the property at all,
So let me go. All right.
because it's an agricultural building.
So we're gonna say get county permits. 90 days after their mother's passing, with
Or she no longer lives there.
or she no longer lives there. It has to be the living quarters have to be torn down and the building has to be reverted to agriculture. Otherwise, everything's back on the table. So all the permits have to be, all the variances would have to be reapplied for. Does not carry with the property if the property is sold. Anything else?
I'm gonna ask the question of the permits with the county, the fact that the building already had water and sewer and all that stuff in 2017 when it was built, and they just tapped into it. What is the purpose of asking for county permits?
we don't know that they have the county permits for it, electrical, occupancy, things like that. So I mean, it's another level they have to go through to get the approvals, and then it's up to the county at that point.
I mean, keep in mind, these are living quarters, right? Without permits, I mean, keep in mind how if something catastrophic could happen, and again, I know that your husband's a builder, I'm sure he did a fine job, that's not the point. The point is that it could be liability on the township and the county if these permits have not been pulled.
Okay.
So that is why there is that concern. And so to have a condition at least go through the process, I think is a very important factor if you're at all looking for my opinion.
Okay. Is that something we can ask, that they pull the permits and pull permits and obviously show to us 30 days that the permits were pulled and this and that?
You can ask for that, sure.
Okay.
But, I mean, I don't
Just
know
to
if that
make
was one of the conditions.
No,
It was
but just to make sure the permits are pulled within a timely manner and it's not just sat on for the next 6 months.
Yeah, you can certainly
Okay.
add up.
So permits be pulled in the next.
Yeah, I would say start the process of coming into compliance with the county within 30 days.
Okay.
I think that should have a quicker timetable. I think the official record should also state the name of the tenant.
I agree. Okay.
And can I clarify?
Yes.
On not only getting the permits, but following through with the inspections and getting final
Yeah.
approvals
Yeah.
from
So
the
as he
agencies
phrased
as
it,
well.
not just pulling
Yeah.
permits, but start the.
But actually get all the appropriate approvals
Yes.
as well.
What was the verbiage you
Then should
used?
there be something about coming into compliance with X number of days, or is that too?
That would be up to the
structured?
county.
The county could take longer than what we say, and that's not fair to them.
You could throw out a time frame, but I don't know. Yeah.
6 months, they have to be in compliance with the county.
I was
Provide
like,
evidence to the township within a certain amount of time, whatever.
That
they
they've
say,
started the
6 months,
process.
That they have all the proper approvals from all the county agencies.
okay.
Okay, so I'm gonna read this for us. We'll read it for you once we're all on the same page. So we're gonna get require them to get county permits, inspections, and approvals within 30 days. And then provide evidence of, do we want to say within 120 days to the township, or?
As long as they've pulled the permits, I think within the 30 days and shown that they've started the process.
It's up to you.
Is that sufficient so we're not?
I don't know what the county requires, so again, the point is that they provide evidence that they're meeting the conditions.
Okay.
Okay, so get county permits, inspection, and approvals within 30 days and provide evidence to the zoning inspector of such within 30 days. Let's see, we'll need the occupant's name. Does not carry over with the sale or transfer of the property. Within 90 days of the tenant no longer occupying living quarters, that the living quarters will have to be torn down and the barn put back into agricultural use. If it's not agricultural use, all required zoning permits will have to be reapplied for. Are we okay with that? Okay, so I'm gonna ask you if you wanna stand up and come up here so that we can get it on the record. Right, so what is your mother's name?
Susan Babbitt.
My mom is Susan Babbitt.
Susan Babbitt.
And Susan Babbitt is the one currently living in the 60
Yes.
square foot.
Okay,
And solely Susan Babbitt.
Yes.
so do you agree with the conditions that you will get a county permit, inspections and approvals within 30 days for the property?
Can you clarify that for the entire building?
For
The living quarters, right?
Yeah, I would think for the addition that wasn't approved,
Yeah, for the 600-foot
living quarters.
living quarters within 30 days,
Yeah,
get
commence the
compliant.
process.
Start the compliance process with the county.
provide that to, right. Get county permits, inspections, and approvals within 30 days for the
600 square foot.
600
living
square
quarters.
foot living quarters addition to the barn. within 90 days after Susan Babbitt is no longer using the living quarters. You will tear down the living quarters, and at that time, revert the barn back to agricultural use. And if it's not being used for agriculture, you'll have to reapply for the zoning permits that would be needed,
Within 90 days, bring the building back up to code.
bringing it back up to code. And
Living
that,
quarters done, back up to code.
and that this
Simple
is,
as that.
and then also these conditions do not carry over on the sale or transfer of property. Do you agree to that?
Yes.
Is there anything I missed? Okay, so now we can vote.
You can do a motion and a second and then
Okay.
vote on those conditions.
So the motion will be for approval with the conditions as stated and approved to by the applicant, correct?
Temporary approval.
And it's only on the first two. Correct?
That's only the first two items, correct?
Yes.
It's A and B.
Yeah, that's all you're talking about right now. It probably good to have someone restate the motion with the conditions, so everyone understands what's being approved, if you vote yes.
Okay. So I'll make a motion
I can read the conditions.
to temporary approve the variance application 2024-152 by Martin and Denise Babcock at 7660 Hermitage Road, referring to point
Babbitt.
A and B, which would be use variance from section 1503A1, allowing building to be constructed and used in violation of the district requirements, and B, use variance in section 1503A4 to allow the accessory building to be used as living quarters, with the conditions that the 600-foot dwelling living quarters would be occupied by only Susan
Babbitt.
Within the next 30 days, county permits will be pulled and applied to and given proof over to our zoning inspector that you guys are
With inspections and county inspections and approvals within 30 days.
within the 30 days proving that. Within 90 days after Susan is no longer in the building and living quarters, that those living quarters will be taken down and the original 1920 square foot barn will be put back into the original agricultural use.
Meaning it cannot be used to store the business equipment.
Correct. The 1920 be put back into agricultural use only.
And then it does not carry or transfer with the sale. Does not carry.
And this
over
is
or
only
transfer
for
with the sale.
Susan, for the current occupant of Susan, and will not be transferred by sale of property.
The-
Did I miss something?
So,
Okay, that's my motion.
Second?
Second.
I think that's right.
All right, Heather, you want to take a vote?
You ready?
Yep.
Okay. Mr. Rowan,
Yes.
Mr. Falkowski,
Yes.
Ms. Garkar,
Yes.
Mr. Sweeney,
No.
Mr. Bowling.
Yes.
All right, the application.
Then we have the other
And
items, C
then
and D on the
I
agenda as well.
will make a motion so we can
Well, the
discuss.
application, I just want to explain to them that the application was successful with the conditions that were stated. And we're going to move on to the next two variances, okay?
So I'll make a motion to approve the variance application 2024-152 for the same property, C and D. Variance C and D.
Second?
So now we can discuss this.
I think
I think this can be tabled until they have to reapply. I don't see an issue with this square
Until
footage
the
at this point.
conditions are met.
Yeah, until the conditions are met for
so.
previous approval. There's
Bridie,
nothing
for
to
this,
discuss.
for these two, can we somehow tie the same conditions? Or do
Can
we,
we just-
because they're different, but how do we,
you can, but you don't have to. It's definitely an option for you. You can.
so these would be approved with the same conditions that were approved for the first two?
You can make a motion to that, but again, living quarters are a little bit different. The tenant's different. I mean, I don't know.
Okay.
The conditions
Gotcha.
apply.
Right. So this is all talking about square footage of this building. So can we just,
So
Like,
I feel like, I
Can
think
we just
Well,
vote on
let
it?
me just ask
can we
a
just approve
question.
it until
Well, but if
this
we-
other building is
but
taken
if
care of?
if we approve it, then we've approved like more square footage so they could tear it down and make the
No,
barn
it
bigger.
can't be approved because we have conditions that they have to meet.
I don't know. I feel if we did the same conditions, just
But it's, you just
so,
said it
that,
was
so then they have to
different.
reapply.
So Brett, let me ask a practical question here. If C and D were not granted, what would the applicants be required to do?
They would have their standard appeal rights to the court economic lead.
But if they didn't choose to appeal, what would they be required to do?
That would,
Like literally, what would they have to do?
right, they'd have to tear down the building until it's actually to compliant square
Right.
footage. Correct.
That's pretty severe.
Right.
So can we just say that
I would
Apply
do
the
this-
same conditions.
they have to move it to agricultural use, or
Go ahead, Brian.
I would just say C and D, same conditions as A and B.
And then it comes up again when at that time when Susan is no longer occupying the dwelling, everything comes back. And
Procedurally, it seems like it relates the best and it all ties in for consistency purposes. Because if you pass it just as is, that seems contradictory to what you just did with A and B.
because if it does get torn, when it does get torn down, since they agreed to that, it would be, and they revert it back to agriculture, none of these are needed, right?
Hypothetically.
But if they want to use it going forward after that for storage of equipment, then they would have to apply for these variances again. By not putting the conditions on, it's sort of like saying, okay, well, now that you have this building, and if we vote against B and D, kind of defeats the whole purpose of what we just did with the conditions. I mean, I think that's your point, right?
Yeah.
I think this is one that we can say you're using this agriculturally or not, right?
Or you could just grant it.
Well, I think if we're granting it, again, I think it changes A and B, like when we tear down the dwelling, the living quarters, then it allows them to, because it's saying they can have up to 2,500 square feet at that point. So I think by putting the same conditions on, it means that at that point, when everything, at that 90-day window, everything reverts back to agriculture. If it doesn't, then A, B, C, well, I guess C and D would come back on the table. And I think that's, Brian, what you were implying as well.
Yes.
I didn't go to law school. I don't know.
You don't have to.
Well, no, and I don't think
Someone's
it's a
got to
legal
make a motion. You got to make the motion.
Right, there you go.
If you don't make the motion, then we're gonna take a vote.
Okay.
So
right,
make
so-
the motion.
There is a motion on the table right now that we're discussing.
All right. Well,
So we're discussing C and D currently, because that's what the motion is on the table. So the biggest question is, as a board, do we want to allow this to sit until the conditions of A and B are followed through? Do we want to
Aren't they tied together?
deny and that just goes to square one? Or do we want to say, because C and D are talking all about square footage, the barn has to go back to agricultural use now? So is it we wait until A and B are done,
I would,
revert back to normal, or currently right now you gotta go back to agricultural? Those are kind of our three options of how we do it. Do we wait until A and B are done?
so Bridie, from a procedural standpoint, do we need to move to, so the motion was to vote on those two, correct? Right. C and D, can we make an amendment to that motion? Or how do we, what's the process to,
Was it seconded?
Yeah.
Yes.
It was. You can't make an amendment.
okay, I move to amend the motion to approve, variance, do I need to read them?
I think they
Yeah,
probably.
move to amend the motion to approve variance from section 1503A6 to allow 25 60 square foot accessory building in lieu of the maximum 1532 square feet permitted, and variance from section 1503A8 to allow the square footage of an accessory building to exceed the square footage of the principal building on the lot. Conditionally on
I think that's what this is.
conditioned upon the applicant meeting the conditions, meeting the conditions for
Previously stated.
previously approved
In the use variance.
in the use variances.
That should work. For a motion.
Second, do I need a second on the?
Should we confirm that they're willing to agree to that condition?
Yes.
Are you willing to accept the condition that for C and D, you have to meet the conditions previously stated
To get the permits?
to get the, all the previous conditions we came up with? So in order to get the next two approvals, they're temporary, same conditions apply as what we had for you. Yes?
So, take a vote.
Or discuss.
I guess.
Is there,
I'm
are there
gonna
questions
discuss.
within the
Any
board?
further discussion? If not, I guess we can go directly to a vote. Heather?
Okay. Mr. Sweeney?
No.
Mr. Bowling?
Yes.
Mr. Rowan?
Yes.
Mr. Falkowski?
Yes.
Ms. Farquhar?
Yes.
All right, you have been, to kind of put it simply, you've been successful with the applications that you presented, so you can move forward. But you need to pay attention to the conditions which were set forth and agreed to by you. And if you don't meet those conditions, you probably will be back here again.
Okay, so it'll be sent to us with the minute.
Before
Yeah, it'll
there,
be put in writing.
Okay.
and public comment has been closed on this, so at this point, questions would go to either Heather. No,
Yeah,
just
you'll be
Heather.
made aware in
Just
writing
Heather.
of all of the conditions that you have to meet.
Yes, it would be
I
going
know.
to Heather.
Sorry about that, and I hope your mother
It's,
is with us for a very long time.
Thank you for your time.
All right, we have the next matter, which is appeal application 2024-153. Jeff Morano is requesting an administrative appeal from the determination made by the Concord Township Zoning Department on June 28, 2023 and February 29, 2024, that the property located on Fay Road, is there an address for that?
It's adjacent to 11465.
Okay, on Fay Road as being noticed, and being permanent parcel number 08-A-0-0-00-012-0 is in violation of section 1101B, section 1101D, sections 1201, and section 15.02. All right, before we proceed, gentlemen, I want to clarify with council. I've been on this board for 12 years. I've never heard an appeal, so I want to clarify what the applicant must present in terms of an appeal. Can we do that? Is it
Sure.
possible?
Sure.
I mean, just in a summary fashion.
Sure.
So the appeal is essentially stating that we don't agree with a decision that was made by the zoning inspector.
That's what I understand. Or the
Okay.
interpretation is a decision.
And our interpretation of the proposed violations are different than the interpretations from the zoning inspector which lodged those violations, correct?
That's what I understand.
Okay, all right, you may proceed.
First of all, my name is Jeff Morano.
You've been
My
sworn in?
residence- Yes, I've been
Okay,
sworn in.
and your address? Thank you.
My residence is 890 Madison Avenue, Painesville, and of course I own the parcel 1146. I used to own all of that.
I'm sorry, can you keep your voice on?
Yeah, I used to, actually, I was born and raised there.
Did you own the property across the street?
No, but I worked on it on my hands and knees for many
Yeah.
years when the Pomeroys owned it.
When it was a Christmas tree farm.
Yeah, it was a farm. Right,
Yes.
okay.
I planted all those tax plants that were there. Didn't have child labor most of it.
Mr. Sweeney,
Yes.
you did a nice job of boxing what we're trying to do here.
I'm
I
trying to,
served
I'm just
on
trying to
Mentor's-
clarify for myself.
I served on Mentor's Zone Boarding Appeals for over 10 years. Never had an administrative appeal. What we're asking you five to do is say, Heather made a mistake. Now, you've relied on Heather quite often here. It's not an easy thing to do, but I think we can conclusively show Heather made a mistake. And we had to file an
I'm sorry, Mr.
administrative.
Chairman,
Bill on
could you
that.
state your name and your address?
I'll be
and
happy
who
to.
sworn in?
My name is Michael Ray, R-A-E. I have been sworn in. I'm an attorney number 000, 1986. I live at 6501 Durham Court, which is in Mentor, Ohio, 44060. Again, it's hard to say, hey, this building inspector who's done such a good job for us made a mistake on one, but we feel she did. And I do want to clarify for the record right away, on the agenda, for number 3, it says permanent parcel numbers in violation of 1101B and 1101D. It's not in violation of 1101D, that deals with decks. She cited it wrong. She also cited it wrong in the letter to the residents, where she again referred to 1101D. She wanted to refer to 1101C, but again, a mistake.
All right, we'll go ahead and correct that if that in fact is the case.
It is the case.
Okay.
I appreciate that. All right. To get to the history of this, perhaps it's best to have the letter from the next door neighbor read, which I just gave to you. She is an over 80 retired school teacher. She lived next to Jeff and his family for over 50 years. She says, I'm currently out of state, which is so unfortunate. She can't attend this meeting, so I'm asking that Jeff's attorney read this letter to you on my behalf. For the record, my name is Elizabeth Perkins, also known as Betty. I live at and have owned the property at 11495 Fay Road for more than 50 years.
All right, where is that?
That's,
I don't mean to interrupt
if you're
you.
looking at the property from the road, it's the lot to the right.
So the property in question, the lot
Yes,
in question,
yes.
it's from above, looking north, it's to the right?
From
Of
the
that
road,
parcel?
it's to the right. And that would be,
Yeah, the first house on Fay Road, if you're going down off of Ravenna,
Yeah,
would be the 11465 house, the brick ranch that I grew up in.
all right, so it's the first, right, that's the one you grew up
And it's
in.
lot right after that, and then Mrs. Perkins is after that, so she's the lot really close.
So the lot is sandwiched by your property and her property?
Yeah,
This vacant lot
well, it's,
well, it was,
no,
mine was. my
it was his
property,
old
yeah.
property. That property's been bought
Okay,
by
all
another
right.
resident, who also supplied a letter saying he fully supports
Okay,
the use
fair
of
enough.
And I
Jeff's.
sold the rest of the property to the Metro.
Okay, so she says, my house is closest to Jeff Lots, my bedroom windows face his property, I'm the Concord resident who would be most affected by any misuse of that property. Let it be recorded, I have no objection to what Jeff has done to the property by clearing the years of overgrowth, adding additional gravel to what already was there, not even changing the original footprint of that driveway. I also have no objection to how he intends to use it. Perhaps the history of the property would provide some context to this situation. When my husband and I purchased our home in 1973, Jeff's father, Tino Morano, owned the many acres that abutted our property. He lived in that house that he built with his wife and his family. In 1980s, when Tino and his wife became school bus drivers, Tino was also the zoning inspector at that time. The driveway in question was put down. She's wrong on that by 10 years. It was put down in 1970. And they had to put huge amounts of gravel to support the weight of the 2 school-sized buses that were parked there. So that driveway's been there for over 50 years. Decades later, Tino sold the house to Jeff. In doing so, he partitioned his land into 2 lots, one with the house and one as what he felt was a buildable lot, and that's the vacant lot, as per the standards at the time. Tino has always talked about how that land was perfect for Jeff to build a house overlooking the ravine and the woods on the other side of the creek. Upon Tino's passing, Jeff inherited the lot. which by today's zoning and septic requirements is not a buildable lot. And we have a letter in there from Lake County that says, no, this is not a buildable lot. It's too short of a frontage. If you put a septic system in, there's a stream there that goes into a creek, and it would destroy it. And this is a riparian, this is R4. And we want to maintain the integrity of that beautiful, beautiful parcel. He says continued to write, he intends to use it as a driveway to periodically bring in his new self-contained RV for a few weekends during good weather to enjoy the wooded property with his son, with his family. He does not intend to park the RV on the property when he's not there. I have no objection to it. I have known Jeff all his life. He respects the land and his neighbors. Please take this information into consideration and dismiss the violations against Jeff. All right. Driveway's been there more than 50 years. Section 1703F allows for maintenance or reconstruction of use that was once lawful. That's what he did. Jeff merely maintained and reconstructed the driveway. At the top of his application, he asked each of you to go out and visit the property. How many of you were able to do that?
I run by there every day.
Wonderful, Mr. Sweeney. Anybody else? Did not? Mr. Golding?
I did ride my bike down there, yes, last week.
Very good, very good. Mr. Garkar?
I physically did not drive. I looked at aerial
You
views.
just drove by it?
Physically did not drive. I looked at aerial views.
You look at the area.
Yeah.
Mr. Kropowski?
Same for me.
Okay. There's letters of support. 6 of the letters mention the driveway, including one from T.R. Hack, who is an alternate trustee for the Board of Zoning Appeals. Heather also referred to section 1313, which speaks to an arboretum or a camp. Again, all Jeff has is this driveway. It has a fire pit. It has a picnic table. He wants to pull his RV in there a couple nights on 5 or 6 weekends a year, so his family, grandkids can enjoy the property as he had enjoyed it when he was young. If you read through those letters, Mrs. Perkins had written a letter last year saying, hey, let the kids enjoy the frogs, the salamanders, the animal and the wildlife. Let them enjoy nature. That's what our wonderful area is all about. But if you go to section 1313, it speaks to arboretum or camp, and it requires at least 10 acres. Just property is 1.25 acres. It has to be on a major street. This is not a major street. This is Fay Road. You have to have refuge or garbage areas enclosed. There's not going to be any garbage areas. Jeff's RV is self-contained. He has no electrical hookups. He has no need for water. He pulls in. He enjoys the night. Cooks some s'mores. Cooks some hot dogs with his family. Spends the night and enjoys nature over there. It also says that for 1313, the buildings for lodging and camping shall be for temporary occupancy. There's not going to be any buildings. Jeff did not change the use of his property. Sadly, it's not a buildable lot. That's what the problem is. His dad really thought, hey, we maybe could. But if you look at the aerial view there, you can see the frontage is very short. And if you build a house there, you have to go into the ravine underneath, and Lake County engineer said, no way, that's not going to happen. But let's protect that ravine. Let's protect the riparian nature of that neighborhood. So, Mr. Sweeney, you mentioned you haven't had an administrative appeal, nor did I. So what happened is Heather issued that first letter. Jeff went to another zoning inspector and actually had that person write out a use variance. He brought it here to Heather, gave the letters, gave use variance, and he had the $300 at that time. That was in June, the letter came, and he brought the paperwork, and Heather said, well, let me see what I have to do, and did not take the $300. He came out, he goes, man, maybe I should talk to somebody. And through a friend, he talked to me, and I looked, I said, you know, she's not really citing a violation here. You are not using this campground for recreational camping or for public camping. And that's what those sections refer to. Heather referred to a chart in section 15. That chart specifically says public or recreational camp. That's not what's happening. This is not or institutional. This is not a Stony Glen. This is not a Camp Carroll. This is not,
Red Oak.
Yeah, Red Oak, that's a campground. It's also not like a pay to come and camp here. It's got one driveway where one RV goes in there. So I wrote a letter thinking an administrative appeal was an appeal to Heather and the administration before we came to here. Mike Lucas responded, but Heather gave him 30 days. We responded in a couple of weeks. Mike did not respond for over 6 weeks. I was like, what's going on? Now, the last people here, you said, hey, they did it, and then they asked for forgiveness. Jeff kept asking me, can I use it? Can I use it? His son came home from the military. Mike, can I spend the weekend with my son from the military? I said, no, respect the process. Respect the process. The board has to do, but the administration has a role. Well, in Mike's letter on July 17th, I'm sorry, I want to make sure I have the right letter.
So I want to keep this focus in my own mind.
Yes.
You don't believe it's a camp,
It's not by your definition.
and
In any way.
I don't want to keep you from referencing materials that we all have had and we've read. Will you be presenting evidence as to why you don't think it's a camp?
It's not a camp as defined by a recreational camp or
Okay.
a institutional camp.
Will you be calling any witnesses?
I don't have to. Your definitions are right in your code.
Okay, all right. I just want to make sure.
And I read that too.
So I didn't mean to interrupt you. Go ahead.
No,
You can resume.
Your questions have been great
Yeah.
to try to frame everything. But again, section 1313, and then there's a chart, section 15. Heather issued another final letter in 2024, and she prints out this old chart. But if you read the chart over camp, again, institutional camping. That's not what this is. It's not public. Nobody's paying for anything. He's got a chain that says private. He's the only one using it. When we wrote to Mike Lucas, he wrote back finally at the end of July, and he goes, your problem isn't per se the driveway and the fire pit, because in the code it specifically says that fire pits and uncovered driveways do not need a variance. So he put the driveway in over a footprint of what was already there. He put a fire pit there, which your code says doesn't need a variance, and there's a picnic table that doesn't need a variance. You look confused, Ashley. Do you have a question you want me to select where it's at in the code?
That's was in my head
You
going
want-
over Mike Lucas.
What's it?
I was in
Am
my
I saying
head
right-
registering
Am I
Mike
saying
Lucas.
wrong name?
No, you were saying the correct name.
Okay, yeah, he was your private.
Eh.
He was your private attorney, your prior attorney. He
Correct.
retired
Yes.
at the end of
In my
December.
head, I was trying to figure out.
Okay. And that was 1503H that says no permits required for driveways or fire pits. Again, we issued the response 7. I thought that Mr. Lucas would issue a final decision on the administrative appeal, and it was what we applied or appealed to you guys, instead of having to ask you to say, no, Heather messed up on this. There was one time at the end of September, Mike was so hard to get a hold of. I'm sorry, the beginning of September. And I said, listen, he missed out all summer because you didn't respond to this. You didn't give us a final decision on the appeal process, the administrative appeal. He missed out on all the weekends that he could have had with his grandkids. His son came home from the military, and I said, don't do it. I know what you want to do, but he missed out on that. His son went back to the military. Finally, end of September, I said, Mike, come on, it's Labor Day weekend, let him use it. He told me, yeah, go ahead, use it. He goes, I can't believe the zoning inspector's making a big issue of that. But the reason she made a big issue of it, because Mike wouldn't make that decision that those sections didn't apply. She relied on Mike, Mike relied on her, and they went with the definition of arboretum and public campground. That's not what this is. I was on the phone, I was on speakerphone. Martha Euler is back here, she'll swear, if you want her to, that Mike said, yeah, go ahead and use that property, let him use it this Labor Day weekend, and he did. Mike later issued a letter saying, oh, you can't do that, or we'll have to bring an enforcement action to cover his butt. I knew what he was doing, but he gave us permission, and we respected the process. I want you to understand that. Well, again, November, I said, hey, Mike, if you want concessions, we'll say 5 or 6 weekends of summer. You know, whatever you want, but what can we do get this administrative appeal going? Again, couldn't reach him. Finally get a letter at the end of December. I have retired. Wonderful. That's where Ms. Matheny, is that how you say it?
Matheny.
Matheny stepped in, and I gotta say, she's been wonderful and helpful. She's the one who said, hey, Mike, the administrative appeal was to the Board of Zoning Appeals. And I said, what? I've never heard that. That makes no sense. You're asking the Board of Zoning Appeals to say your zoning inspector messed up. Well, she did mess up. There's a driveway there, and Mike's letter, Mike did do one thing in his very first letter. He says the issue isn't the driveway or the fire pit. And he conceded there was nothing wrong with those. He said it was the camping. But again, it wasn't the definition of camping in your code. So what I'm asking for that first appeal is that you say, no, those provisions don't apply to the situation at hand. It's a single driveway. One person, it's private, it's not public, and it's not for commercial use. And then he would like to use it, again, it's not buildable, he would like to use it a few weekends in the summer for his family to come there and enjoy the creek and the nature of the riparian nature of the place where he grew up.
Let me further try and clarify where we are so far.
Yes, sir.
Okay. More so for my purposes than for yours,
You're
Mr.
good.
Ray.
You're good.
Normally, when a person comes before us,
Yes.
they don't claim that the violations that they've been charged with don't apply to them.
I agree.
I think they're implicitly kind of saying, we violated it.
Well, that's
Okay,
my fear
now hold
for
on.
you guys.
Bear with me.
Go ahead.
But they usually say, we violated it, however, it's because of this, and this, or can you please give us a variance? Your client has chosen to do that, ask for a variance, which we haven't reached yet,
Yes.
but gone right to the source and said, this doesn't even apply to us.
Right.
Okay, and so
Two-step
I want to keep
process.
this straight in my own mind here.
Right.
So your client could have easily just asked for a variance instead of the appeal, but he's done the appeal, and then in lieu of that, we have the variance, right?
We've gone 9.5 months.
Right.
For him trying to get to use his
Right,
property.
it's almost like
was
there's
an
a
administrative
problem in
appeal.
search of a,
Yeah, well, Mike,
A solution in
but
search
she
of a
told me
problem.
we had to. But we had to pay $300 for the administrative appeal,
Right.
but she says we can ask for that back, and also $300 more for the variance. Again, I don't think Heather stated a violation, and that's what I'm asking you to decide is that no, this is not a campground, public or commercial type campground.
Okay.
That section doesn't apply.
all right,
And the driveway was been there, and you're allowed to repair it and fix it up. And
okay,
we've got 11 letters there saying, neighbors saying this is a great use of that property.
right, all right, so again,
Can I ask a
Brady?
question too?
yeah, in a second. So Brady, so we're just dealing with the appeal, right, at this point in time, as to the interpretation of the terms in question, right,
Up to what was cited by Heather.
of what was cited,
Correct.
right. Okay. All right, are you finished?
I think so. Again, just to maintain, you asked about the definition or an expert for what a campground in your provision. 10 acres or more, yes, 1.25. It's got to have places for refuge that's enclosed. He's self-contained, he's taking care of his property, his neighbors know he takes care of that property. Outbuildings, there's no outbuildings, there's no electricity, there's no water, it's all self-contained. Those are the provisions for public and commercial campgrounds, like a KOA, that's what I was looking for.
Right, okay,
That's not what this is. It's a one driveway
right,
lot that's not buildable.
okay, all right, thank you.
Thank you.
Now, questions from the board for the applicant?
You can do that.
Yeah.
Sure.
Sure. Guys have any questions? Anybody? Actually, you said you
We're talking about the appeal only currently.
only. Yeah.
I guess there's a slight confusion at my end.
Go ahead.
What? We're doing the appeal first.
The administrative
The administrative appeal first.
Yes, ma'am.
What is the reason between doing this administrative appeal instead of just getting the variance to put
I'm glad
camp
you-
on it?
I'm glad you asked that question. Again, it's been 9-10 months.
That's I just clarified.
Since of June. But
And that's where I'm confused with trying to.
for common pleas court, if you deny his appeals, we have a right to go to common pleas court. She'll tell you that. And I want to make a record And the record is that we exhausted all our opportunities to get this straightened out. And if you rule against this, then we have to go to county police court. And so I'm making a record in that regard. So the first is administrative, which we tried to do, and unfortunately, until she came along, your new attorney came along and educated me. But I'm glad Mr. Sweeney said, hey, he's never seen administrative appeal. I never saw one either. To me, administrative says you go to the attorney, you go to the administration, you work with the zoning inspector, come up, and then issue either a denial or a granting. And in fact, I asked her, I go, his due process rights were violated because there was no denial. And that's when she says, no, you've got to bring the administrative appeal to the board. So that's why we're here.
Okay.
So why was there not a variance in the first place? Like, why did we? That's where I'm missing. Is why did we
think,
skip
my
from
understanding-
administration
I talk
and
out
not
loud,
doing the
so-
Yes, go ahead.
Yeah,
My understanding is this, is that he doesn't think he should have been wronged in the first place.
like he didn't need to apply for that variance
That
in
he
the first
didn't need
place.
to, but he did apply for it. So if the administrative appeal, play along with me, if it doesn't go his way tonight, then he still can fall back in the variance, and then he can get the variance. Is that my understanding?
Yes.
But, and you kind of confused me with, so if the appeal does not go your way, but you do get the variance, then what were you saying about the appeal now that?
When you go to court, the court will say, did you exhaust all your appeals?
Right.
She would say, he didn't make use of the administrative appeal process. I would say, I wrote letters and everything else, and she says, that's not the correct procedure, and she'd be right.
But if you get the variance,
If I get the variance, we're going home.
I guess so. That's my question is
let's
why
vote on the variance.
why didn't we do the variance in the first
I would like
place?
first, though, to vote on this.
But why did we not do the variance in the first place? What did
Because
they not do the variance in the
So-
first place?
Because this
he
was about
wanted
the
to.
letters.
Because that's what he wants.
That's
I wanna make the
his
record.
right to
Right,
appeal
got it. I understand
and say
now.
that
Oh,
there was
there
an
it is.
interpretation error.
I get it now.
on
And
the
Heather.
zoning inspector.
The
Correct.
zoning inspector.
So,
So that is an administrative, right, and a due process right of theirs, and they have to exhaust it if that's what they want to do, and that's what he's doing. So it has to be ruled on first, because if you rule that in fact she did not err, then we have to go to the alternative of the use variance.
which he's applied for already.
Correct.
Right.
He's already good.
So otherwise,
Okay.
then he,
So this administrative appeal is basically saying, hey, we don't need the variance, we can just do it.
But what I would do is still ask for the variance because I want to wrap this, it's been 9 months.
Right.
Yeah.
But
So, but
it
that's
would
what the
give us a
administrative
stronger
appeal-
position if the administrative appeal was granted, saying, no, she didn't say that.
So the administrative appeal is
Yes.
basically saying, if we say that everything was wrong, and they are in the right in this administrative appeal, there it's basically saying they don't need this variance in the first place.
Right.
Right. But out of a
That is why we went to the administrative appeal before
Yes.
going straight to a variance.
Got
Is because you're
But again,
claiming
out of
that you
abundance of
don't need a
caution,
variance.
we still are going to do the
Gotcha.
second.
Okay, that was my disconnect.
Okay.
Thank you.
Okay. Anybody else?
I don't have more questions for them.
All right.
So is there a motion to vote on it?
Well,
That motion's already
we,
been.
there's no other questions
For you guys.
from the board
Yes.
for you guys.
Okay.
All right, so thank you for your presentation. And we now ask if there is anyone in favor or opposed to this matter that is here to speak.
Mr. Chairman, I would request to speak.
Okay, thank you, Heather. Please approach. Have you been sworn?
One moment.
Go right ahead.
Heather Freeman, Concord Township Zoning Inspector. Yes, I've been sworn in.
Okay.
Okay, thank you. Okay, I just want to start out by saying that this board's only decision for this appeal is to determine whether or not I erred in my interpretation of the zoning resolution as it pertains to the property and the uses in question. I will present to you tonight the facts that pertain to the violations that I cited and offer an explanation as to why I feel they relate to the property and the uses in question. But I just wish to remind you that this is not a conditional use permit. This is not a variance application. Personal desires and family histories, while offering a glimpse into the prior use of the land and the perspective of the property owner, Mr. Moreno, does not have any bearing on this appeal. I ask that you simply look at the violations that I listed in the final notice that I sent to Mr. Moreno on February 29th, 2024, and review the sections that relate to those violations with me so you can determine whether or not they do in fact pertain to the property and uses as I believe they do. So here I'm handing you Exhibit A, This is a copy
Here we go. So,
of the final notice that is dated February 29th, 2024, from myself to Mr. Josh Moreno. We're at 890 King Madison Road.
got it.
No, you do not. You do not have this.
That's that.
Nope.
You do not have this. These are my exhibits. They are not in your packet.
Okay.
I'm entering these into the record right now for the
On the
record.
record, it is identical.
Here's your review if you'd like. Okay. So you will see that I've cited 4 different violations in this zoning resolution, including sections 11.01B as in boy, 11.01D as in David, 12.01, and 15.02. And I do have with me this evening as well the copy of the entire zoning resolution that was in effect at that time. There was a statement made earlier that I cited the wrong section. I'd just like to show the board, if you don't have your own books with you, I did not cite the wrong section. 1101D does indicate is what I was pertaining to, not Dex E, as it was stated by the attorney previously.
What is the date of that code, please?
Okay, so section 11.01 of the zoning resolution contains a list of buildings, structures, and uses that do require a zoning permit. Section 11.01B states that a zoning permit is required when there is a change of use of an existing building, accessory building, or lot. This lot was changed from virtually a vacant piece of property to an area that will be used for camping without a zoning permit being issued. As Mr. Moreno's attorney stated, the property, well, as in his, he might not have stated it here, but it was stated in some of the information that he submitted. The property was mainly overgrown until he recently improved the lot by installing a gravel driveway and fire pit. On June 28th, 2023, I received a phone call with a complaint from a neighbor that the property on Fay Road that we're speaking about tonight had a new driveway and parking area installed along with a fire pit. The caller also stated that there were rumors that the owner had the intentions of bringing a 40-foot camper to the lot for camping. Upon an inspection conducted on that same day, June 28, 2023, Mr. Morano happened to be there at the property. He told me about how he resurfaced the driveway and created an area to park his RV so that he and his family could use the property for camping on the weekends. Here's a photo. This is Exhibit B that I'm entering into the record. A photo that I took on June 29, 2023 from the street showing the recently improved gravel driveway and fire pit. Thank you. So as you can see, there's freshly laid gravel, a little bit of, and a fire pit over on the left-hand side of the photo. Additionally, I have another Exhibit C. This is a near map oblique view of the property that was dated March 8th, 2023. This came from the Lake County GIS Navigator site. This shows an oblique view of the subject property about 3 months prior to the driveway being resurfaced. Now it doesn't show the parcels are not outlined, but you can see the blue little kind of arrow there in the roadway. And if you compare that to Exhibit B, you will notice some of the markings on the street for the bike path, and that is right there in front of the vacant lot that is flanked by the 2 other homes that they spoke about previously, Ms. Perkins to the east. So based on that image, I do not really see any kind of driveway or improved area. It, to me, looked overgrown. So it is my position that the property owner changed the use of the lot from vacant land and improved it with an area that was to be used for a camp, which requires a zoning permit as set forth in section 1101B, which has not been issued by the zoning inspector. Okay. Secondly, It is also my position that the property is in violation of 11.01D, which states that any change of a non-conforming use to a different use, conforming or non-conforming, or the expansion or extension of a non-conforming use requires a zoning permit. It was stated that the driveway previously existed on the site where a school bus was parked for years when his parents owned the house next door. It was also explained, Mr. Moreno had explained to me that his desire was to now use the property as a place to park his RV and camp with his family at the lot for a limited number of weekends per year. He also informed me he spent roughly $5,000 in gravel to resurface the driveway and parking area. While the existence of the driveway on a lot may have been considered a non-conforming use, it is clear that the use of the property has been changed to a different use. A campsite for Mr. Morano and his family has been created on the property. This change of a non-conforming use to a new use of property requires a zoning permit to be issued by the zoning inspector as set forth in section 11.0D. At this time, I'd like to give the board exhibits D and E. These are both near map images of the property with the date of April 6, 2024. These were taken again from the Lake County GIS Navigator site. Okay, I think if you look at these images, one being the oblique, exhibit D, you can now see the location of that resurfaced parking and drive and fire pit as it most likely exists today. This was, again, I indicated April 6, 2024, and then exhibit E shows the approximate locations of the lot lines. Those are outlined in red. And again, the resurfaced driveway and parking area and fire pit that's going to be used for camping. Furthermore, the property that I also stated in my violation letter is in violation of section 12.01, which states in any district it should be unlawful to use or permit the use of any building or premises or both or part thereof hereafter created, erected, changed, converted, or wholly or partly altered or enlarged in its use or structure until a certificate of zoning compliance has been issued, therefore, by the zoning inspector. A certificate of zoning compliance is issued by the zoning inspector after personal inspection and determination that the use of the structure and or land conforms to the approved plans and the use filed with the zoning inspector and upon which a zoning permit was issued. The property owner does not have a certificate of zoning compliance for this use of property. And the last violation I cited in my February 29, 2024 letter is that the property is in violation of section 15.02 use regulations. This section lists all of the principal and accessory uses that are allowed in the various residential districts. Additionally, 15.02 requires that any use be in full compliance with all the applicable standards and other regulations that apply to the specific use and parcel. As stated previously, the lot has been changed to a camp where the property owner intends to bring his RV to and camp in it with his family a few weekends throughout the year. This use meets the definition of campground as set forth in section 5.02A36 of the Concord Township zoning resolution. This is exhibit F, which is page 5.2 and 5.5 of the zoning resolution. And you can see at the bottom there is starred the definition of campground, and I'm going to read that into the record. So campground, an area or tract of land with accommodations for temporary occupancy are located or may be placed, including cabins, tents, and major recreational equipment and which is primarily used for recreational purposes and retains an open air or natural character. It was the only thing I could figure out it was. This is exactly what Mr. Morano was using the property for, and how he's expressed to me how he intends to use the property. In fact, he admitted that on the weekend of Labor Day in September of 2023, he and his family camped at the property in his RV. I also had a resident call me and tell me about that, who took photographs as well. Camps in the R1 district require a conditional use permit to be approved by the Board of Zoning Appeals as set forth in section 15.02. The property owner does not have a conditional use permit approved by the Board of Zoning Appeals to use the property as a camp. Therefore, in my opinion, that the property is in violation of 15.02 as it is being used for a camp without being in full compliance with the district requirements and does not have a conditional use permit approved by the Board of Zoning Appeals. Finally, I just would like to add that should the board find that I did err in my determination, that there would likely be other zoning violations if the property is used in this manner. The most pertinent would be the provision of section 29.10B3, which prohibits recreational vehicle to be parked or stored on a residential lot from having fixed connections to utilities or to be used as living quarters. Also, section 29.10B4 requires recreational vehicle or trailer to be parked or stored behind the building setback line of the district. And section 29.10B5, which requires recreational vehicles to be adequately screened from view from the adjacent property owners. Additionally, if you look at the 2024 ortho photo, which was Exhibit E, there could be potential encroachments of that driveway onto neighboring properties. And that's all I have, unless you have any questions for me.
Thank you, Heather. All right, is there anyone else here to speak for or against this application?
I do need to respond to her.
Okay.
Oh, yeah, I've got the right. Okay.
All right.
All of a sudden, she's coming up with 2910B, 2913. That's not in any of her violation letters. She's expanding.
Well, you're looking at, the only thing I'll say, is I've got the permits that I.
Well, have you been sworn?
I'm sorry, what?
Have you been
Yes.
sworn?
Yes,
Okay.
A year ago, in June last year, came up, first of all, before I even get into this, it's never been my goal to make this an adversarial or confrontational situation. Okay, that's not any fun for anyone. And through osmosis or whatever, I know a little bit about zoning, just because my dad was a zoning inspector here. You know, I recognize Heather's trying to do her job. This is not a personal attack, so I can look you in the eye and say, okay, I'm just trying to defend myself. It's a driveway. When you left it, they even asked me, did you put that culvert pipe in? I said, no, Dad in the Painesville Township school system did back in 1970 something. If you go over there on your bicycle, look down the right side, you'll still see the big honking construction grade gravel that I covered up with the limestone, but some of it got kicked out. That's what they drove school buses on. That's why I grew up. The use hasn't changed. My swing set was over there. My kids' swing sets were over there. Okay, we played on that. Me and Mrs. Perkins' kids played on that lot. Okay, the culvert pipe's still there, the old rails are. I just had to go over there last week, hopefully before you went over there, I wanted to make sure we were good. Already, the helicopters come down, they're all in the gravel, and I had to go over and clean all that up last week. I cleaned up the ditch last week. I went over there last fall, and I've been trying to keep it nice. Leaf blowed the whole lot. You know, keeping it nice and clean. I don't want, is there gravel around the fire pit? Yep, I don't want to be the guy that burns the woods down, you know? But it's not against the law to put gravel and clean up the driveway. I taught my kids how to shoot over there. And my wife's son is my stepson. We shot, that ravine was a perfect backstop. You know, did I back my truck in and then briars scratched it all back? Yes. So it just, I don't want an adversarial or confrontational situation. But I did go up there in June with these permits and $600 actually. Okay. And to cross her Ts and dot her Is, and I get it, with these permits, one was for a conditional use permit, but she said, let me check with legal. So I left with cash in hand and permits printed out.
But you gave her the permit. You gave her what you had in the file.
No, I don't remember if I did at that time or not.
I thought you
don't
said you
remember.
gave
I
her-
went up
you
there
gave her
later.
letters.
Yeah, that was later.
All right.
You know, after I had been put in contact with you. Because some of the residents were like, this is nonsense. It's your driveway, it's your lot, you should be able to do what you want. I've always been honest. I've always been transparent. And I tell people, yeah, my goal is ultimately to maybe bring my RV over there, but it was, you know, it needed to be cleaned up. I'm not storing it there. I don't have electric there. I have a WISP-required generator. I have 100 gallons of fresh water stored in my RV, and I have my own place. When I leave, it leaves with me. It's that simple. But it's a shame that a year later it's come to this. I'm sorry, I don't mean to get heated, and again, I don't want to be confrontational. But it's a driveway. It's a gravel driveway. And I told Heather, again, not a personal attack, but as it comes up, the conversations that we had, it's all getting blended together over the last year, that I'm not gonna use it until you tell me I can put the RV over there. Right now, it's a driveway. And if you look at the footprint, I had to go over and measure, because, you know, part of my limited high school sketching skills, measure it and draw it out, but one's shorter, that's where Mom's bus went, and the other one's longer, where Dad back is, and so that, I figured, okay, that's where I'll put the RV. I'll put it in the long section, unhook my truck, and put it in the short section. That way I'm away from the street, you know. I don't know what else I can do. It's a fire pit, a picnic table, and a gravel driveway. I can't believe it's come to this. It says in the zoning resolutions, things you do not need a permit for. One is a driveway. You know, I'm sorry I didn't fix it up soon enough, but I was busy dealing with Dad's condo after he passed away, and it took a year to clean that all up. So I'm only one person.
I
Sorry.
do have a question
I'll
for what you
listen
just
up,
stated. You brought in a permit, or you filled out a
I still
permit.
got them. They're dated.
No, you brought one in. Something happened within discussions that it was,
Right, it was a discussion.
we need to talk to legal, so you did not file that permit.
Right.
And that's where this conversation then started with legal.
7/10/23.
Yes.
Literally a year ago.
During her talk, she mentioned resurface the driveway. Resurface the driveway. 1703 says it allows for the maintenance or reconstruction or use that was lawful before. That was the driveway. It was there. Mike, your other attorney, in his letter, Exhibit 10, the second page, he conceded that the zoning violation per se is not that he's building a campsite. So he conceded the driveway, fire pit, picnic table, those were okay. That's the second page of Exhibit 10. But he went on to say, rather, his clearly expressed use for the property for a camp or campground staying overnight is what the zoning page or zoning speaks to. But then they cited again, commercial camping, camping for profit. It doesn't meet any of the
When was the property split into two?
When I bought the house from my folks, 2003-ish, I think.
Is when the property was split into two.
Yeah.
prior
but
to being
Dad wanted
split-
to keep that one lot.
Okay,
He
so prior
maintained
to it-
Buildable is buildable, it's not buildable.
Right, but prior to it splitting,
One lot.
when it was one lot, prior
Yes.
to about
It used to be-
2003 or 2002,
Hang on.
buses were on.
The property from 1970 on. When did your dad buy the
So
property?
the question is
Oh,
when you
1960s.
when you split the property in half into two different parcels. After the point of splitting into parcels, was that driveway being used? Were buses being stored on it? After splitting in half, what was that parcel?
I was
What, it
using
just
because when I lived
sat
there-
vacant?
No.
It was a vacant lot still, because there's nothing built on it, but he would drive his car there, clean some stuff out, which is exactly what you're allowed to do.
Right. So, but because we're talking about changing parcels of usage, when that parcel was split, approximately 2002. Prior to 2002, buses and things, there were a driveway there where stuff was stored on it. After 2002, approximately when it was split, there were no longer buses or anything like that stored on it. It was just simply cleaning up a vacant lot.
It was my
And
stuff.
reestablishing, resurfacing the driveway that was there. That had been there since 1970.
So, okay.
Are you talking about when I moved in?
No, I'm moving,
Years or-
I'm talking about the split of the parcels.
Understand.
Because one of the things we're discussing is
Consistent-
changing what was
consistent.
used.
Now, if you get overgrown, he cleared that out, and if you've been there, you're gonna see. And just like the next door neighbor lady said, he did a great job on it, made it look wonderful, and it's private.
So we can agree, he did a great job, looks awesome.
Yes.
I would camp there, A+. But, not loud. I'm not gonna camp there. But I think we're just talking about whether or not Heather was right or wrong in going, because as I mentioned, I rode my bike down there. If there was a driveway there, it got grown over, right? And I'm not doubting that there wasn't a driveway there. If he says it was there, I believe him 100%, right? So the zoning inspector's job, from my perspective, is she goes down there, she sees this guy down here doing stuff on here. She's like, oh, what's this guy doing? And was there a driveway there? It's like, I don't know if there's, I can't see a drive. I mean, I'm looking at my definition of driveway, which is the awesome thing he built, and not the, from the aerials that she gave me and the overhead that she gave me, and I zoomed in on my phone. I tried to find, I couldn't find any driveway there. But, so the question is, was she doing her job? So, and in my opinion, it's like, well, yeah, she's down there, she sees this guy doing something, and she's supposed to say, I think he's doing something, so we gotta bring him in and talk to him about it, hence the appeal. Now, he comes in for the conditional use, we look at it and go, oh, camping's cool, he can camp there, totally sweet, here's the conditions, or whatever. But, so now the thing is, we just have to discuss, did Heather, and that's what I'm guessing what he's here for, is he doesn't think Heather was supposed to do that on this parcel.
Right, which is where I'm getting at.
Got it.
At the split of the parcel in approximately 2002, from that split, it was a vacant lot. At that split.
Footprint of the driveway was still there, as the neighbor said,
And
and
for
6
my
letters.
comprehension is, that's part of the questioning is, a vacant lot, do you need permits to take a vacant lot and have camping there, have an RV there, have other things? I think that's the questioning.
I think she can't ignore it, if that's what you're asking.
But you can't classify it as a recreational or commercial campground. It doesn't.
Well, regardless, she had to go down there and say,
Well,
there's something going on here, so we gotta bring this cat in here to talk to him about it.
I got
That's
no
it.
problem with that, but
Yeah.
citing that section is wrong.
Well, so.
And that's a mistake.
Well, that's your opinion, but if she thinks that that was it, then that's the reason for the hearing. We come in and we're like, hey, so, Jeff, we got this campground here, Heather says you did this, that, and the other, we listened to it, we're like, well, you know what, it's pretty cool, camping's cool, Jeff made it great, the neighbors all think it's cool, rock on, have fun, and then it's over, right? But, so I think I don't wanna besmirch the legal process, but I just think we're wasting time on going what Heather did wrong, and we just need to talk about camping.
Do you want to go to the second appeal?
We need to first do the
Yeah,
first
well, we-
appeal.
yeah.
We need
Yeah.
to finish this first.
The only question is, I'm getting letters saying, remove the gravel, remove the fire pit, remove the picnic table.
Well, if you get the conditional use, you don't have to.
Right.
Right. Do you want to waive your right to further consideration of the administrative appeal and go directly to the,
Will you give him his $300 back?
That's not
I,
for us.
She
I
said,
don't,
The
I don't-
$300 is for us.
I
it
don't,
is permissible.
I don't know how that works.
I've never refunded,
Because you've never done something, doesn't mean you can't do it. I talked to your attorney and she said we could ask.
well,
And you guys have that in your discretion.
Sounds good.
all right, well, we'll take a vote on that, but
Okay.
are you willing to forego your appeal and move directly to the variance request?
If you specifically say that section on commercial campgrounds does not apply.
It doesn't say commercial.
It does.
All right, so then,
15,
we have to
section
take a vote on what
15
you're saying. You're gonna force us to, or you're gonna ask us to decide.
That's fine.
Okay.
But again, in order to protect our rights, when it's over, I'm gonna ask each of you to explain your reasons for denying the administrative appeal. I'm allowed to do that.
I don't know that you're allowed to do
I'm allowed
that.
to do that. What I'm doing is protecting the record, should we have to go to common pleas court.
Just give your reasons during your motion.
Exactly. Yeah, we're not gonna take any questions directly from you.
That's fine, you give
After
your
public
reasons.
comment.
Right.
Once you give your reasons, they're on the record, and then
Right.
we can show where they're.
Absolutely, absolutely.
Yeah.
All right, so then, is your presentation on the administrative appeal
Administrative appeal done.
complete?
We're done.
Okay, any further questions from the board?
Sit down.
Can I ask Heather, can I ask you a question?
Of course.
Sure.
Oh, for Heather?
For Heather.
Okay.
Can Can you,
I'm afraid my ass, I've been sworn in.
Yes.
Thank you.
can you, all right, I just need, we're talking about the commercial camping. What section was that in? Or do you know, because when we look at
1502.
1502.
Camp is a conditional use permit.
Oh, public and
Definition of
institutional.
camp is, I read to you from section 502.
And then this is where the public and institutional uses are. That's where. 'cause
Okay, I was just reading the definition of campground.
And so where Exhibit F, where does that come from?
That is straight from the zoning resolution.
Section
Page-
5.
Yeah.
504.
That's fine.
Yeah, it just didn't say commercial in there, so.
And it was never cited in any of her letters.
Excuse me, sir, 'cause I'm up here right
Yeah.
now.
Yeah,
it's 20%.
yeah, you can't, she's being
I'll
questioned.
finish it.
Yeah.
So I think the question was around, so, we have the definition here of a camp, an area of land which generates temporary occupancy. And so I think there's just some confusion about a camp versus an institutional where we're requiring, was it 10 acres minimum?
Camp
So-
versus commercial camping.
Commercial.
So there
camping.
is no, this definition of camp, if you recall, does not indicate whether this is commercial, nonprofit,
Right.
private, anything. It does not allude to if it's public, private, anything. The definition is an area or tract of land which accommodations for temporary occupancy are located or may be located, including cabins, tents, and major recreational vehicles, recreational equipment, and which is primarily used for recreational purposes and retains an open air natural character.
Okay. Do you have any questions related to that?
Any other questions?
And I guess if I'm up here, if I could take a moment to state, I'm not sure what section 17.07 is that was referred to a couple times this evening. You don't have. I think that's in
Purpose and
regards to repair-
intent.
Oh, repair and setbacks. That's what that is. Okay, I never cited him anything on that. So
Do you know what part of 1701 you're asked?
I didn't cite any kind of thing in
17,
section
okay.
17, so I was confused by their statement. But
It is labeled in as purpose and intent. I can read all of it.
That's
but
okay.
The bold
Yeah.
is purpose and intent.
all right.
All right. Okay, so. Are you making further presentation?
All I will say is that last section she said was never in any of her letters, although
Okay.
the attorney did reference it, and when I responded to him, which he never sent a letter back,
I apologize. The last thing she stated talking about 15 or 17?
the
15? What are you referring to?
section where you define camp, where she defined camp, what is that section?
The definitions in our zoning is what she defined camp from. It's just straight up our definitions of zoning.
Yeah.
That's
Okay,
where it's
exhibit
about-
F.
Yeah.
Yeah,
exhibit
never
F.
got that, but when I responded to Mike, I said, Mike, and how many of you are attorneys? Anybody?
Just continue, sir.
All right. When you look at a document, you look at the four corners of the document. The only time camp is referred to is the institutional and recreational. That definition goes to them. And that's what I told Mike, and he never rebutted it. And again, in his letter, he stated the issue isn't the driveway, it's not the fire pit, not the picnic table, it's whether or not he stays over there. And then that goes to the definition of institutional campsite.
All right, thank you.
Okay?
All right, so if there are no more questions from the board,
To them.
well, is there anyone else speaking for or against? If not, we will close the public hearing, and I will entertain a motion.
Define it again.
So moved.
Well, how does this work for an appeal?
Well,
Is there-
I'm
I'm sorry.
yeah, we're gonna get to that point, but
I'll
I just
second.
want to entertain the motion on, for the administrative appeal. Second?
I'll second.
Okay. Discussion. Now, Friday.
Yes. As far as I know, this being my first appeal, I don't know of what standards the board needs to review in making its decision. Are there any standards? There are. So in Ohio courts, essentially the zoning inspector, through our zoning resolution, is required to interpret the zoning resolution
Okay, now,
in her enforcement.
now a question for that.
Sure.
Is the zoning inspector's interpretation and decision presumed to be valid?
Correct. That's
Okay.
on an appeal. So in other words, let's say you say that she did not err, and there's an
Right.
appeal to the court. The standard of review at the court is that her decision is considered to be and presumed to be valid unless
Until
the
proven
shows-
by a certain
correct. There's
preponderance
like
of
a
the
rebuttal,
evidence.
right? The presumption is valid upon.
But for our purposes here, it's
We are-
also,
You can, yes. At the end of the day, you're just looking, is it reasonable interpretation in light of her
gotcha.
duties as a zoning
Okay,
inspector?
gotcha. All right. Did you have,
I was
does it answer
asking,
your question?
I was asking procedurally just how it was going
Yeah.
to work, and I think that helped clarify
Right, that helps
And
me.
then it sounds like there is a typical roll call vote at the end.
If there's no further discussion.
If there, once there's no discussion, there will be a roll call vote.
Exactly. Yep.
Thank you.
Thank you. Is there any other discussion?
I think Heather did her job.
All right, well,
Right.
if there's no other discussion, then we'll take a vote.
Sure.
I was gonna say,
Oh, I'm
before we
sorry.
do take a vote, I think might for all of our, do we want to just simply do yes, no, or do we want on the record a little thoughts of why we're gonna go yes, no?
Well, I'll just tell you right now that I am going against the weight of the evidence as presumed to be valid unless proven otherwise. If my vote reflects that, that her decision was valid, then the implication is that it was not rebutted sufficiently enough.
So is a yes vote in support of the decision that Heather made, or is it in support of the appeal?
It's a great question, because actually you just made a motion. You didn't say motion to approve the administrative appeal or a motion to deny the administrative appeal. So maybe we should go back and amend the motion.
Okay.
And if you are to approve the administrative appeal, I believe that you would then be siding with the appellant, saying that in fact she erred. If you are denying or voting no to the motion approving, right, you'd be saying that she did not err.
All right, so the new motion is to entertain a vote as to the approval of the appeal, which means the appeal is successful, and that's a yes vote, or a denial of the appeal, which means the appeal is unsuccessful, and that's a no vote. Is that good enough?
No, so it would be a motion, sorry, just, it's confusing. Motion to approve the appeal. Essentially saying that the applicant has proven that the zoning inspector erred in her
Okay,
interpretation.
all right, so the motion is
So
to...
then it would just be a yes or a no vote. You
Is
don't
it-
then
Gotcha.
do anything
Or
else.
you
Okay,
could
mo-
make a
motion
But is it an
to deny
amendment to the motion?
appeal,
It
too.
is an amendment to the motion,
Okay, so
thank you.
Amendment to the original motion to approve the appeal.
I'll second that amendment.
So,
Now, a yes
one
vote,
second, a yes vote is for
Approval.
approval, meaning they made a
rebuttal,
good case in
They win.
stating,
and a no is saying that Heather is correct.
Yes.
or is a no stating that there was not sufficient evidence to prove otherwise.
Which means she didn't err. So
Right.
it's the same
Okay.
Yeah,
Right,
Wanna
no
make
is the
sure I'm clear.
appeal is unsuccessful.
correct. All right. Having forwarded or presented the motion, received a second. Take a vote.
Mr. Goley?
No.
Mr. Sweeney?
No.
Ms. Garpar?
No.
Mr. Rowan?
No.
Mr. Falkowski?
No.
All right, Mr. Ray, the appeal has been denied. Would you like to proceed to the?
Yes.
Well, we will be proceeding to the
Yes.
variance.
That's fine.
All right, the second matter up is variance 2024-154. A variance is being requested, a use variance from section 1502 to keep the existing driveway and fire pit and to allow for the parking of his RV and sleeping in the RV a few weekends during the period from May 1st to September 30th, where said use is not a permitted use.
I don't know how to appropriately ask this, but would it be possible to take a 5-minute break?
Yes.
I think it'd be great.
Let's take a 5-minute break. I don't know about that. All right, meeting is, has returned in session. All right, we stated the basis for the, for case number 2024-154. Mr. Ray, would you like to
Basically,
proceed?
we got so many people here.
Did we make a motion for this one yet before we tabled?
Yeah, we did.
No, 154. I don't think we made a
To
motion.
accept jurisdiction? Is that what you're
No,
asking?
No, we haven't gotten to that point.
we just called it matter.
We just called them up and then we had to take a potty break.
Right.
This is number,
Okay.
this is number 4
Sorry.
on your agenda.
Yeah, number
Can
4.
we read into the record the whole
Yes.
agenda appeal?
I did.
The variance application, read the whole thing from the agenda, number 4.
Would you like me to read it?
Okay, I'll do it again. This is a variance requested. Jeff Morano is requesting a use variance from section 15.02 to keep the existing driveway and fire pit and to allow for the parking of his RV and sleeping in the RV on a few weekends during the period from May 1st to September 30th, where said use is not a permitted use. All right, Mr. Ray, you may proceed.
Basically, we got so many people here, we're just gonna go through the Duncan factors, and that's what we'll ask you to base this on. First, may the property be used for any other use permitted in the zoning classification district? The answer is no. It's a non-buildable lot that's represented by Lake County engineers. You can't build a house on it. You don't wanna ruin the riparian nature of that property. There's a stream, there's a creek, and it feeds into Big Creek, and you're trying to protect that. Is it due to unique circumstances, particularly the property and not the general neighborhood conditions? Yeah, it's a unique property because of the 2 streams, because of the going into the creek. It's also, you can't install a septic system because you have to go under the creek and it'd be cost prohibitive. And again, with the soil the way it is, it would ruin the riparian nature of that. And Exhibit 4 is a letter from Dan St. Clair that basically says that. C, will the essential character of the neighborhood be substantially altered, or will the adjoining property suffer a substantial element if a variance is granted? The answer is no. The owner to the left says, this is great, let him do it. You read the retired school teacher's letter. You get people up and down the street who supported it, and we put several letters in there. There is, across the street where the Christmas tree farm, 2 new houses. One of the new houses says, let him use the lot the way it is. There's one who says, no, it looks like he left. He just put a swimming pool in. The street was packed with cars. Yeah, he can do whatever he wants, but a person who lived in your city for 50 years and a non-buildable lot can't do it. So will the character of the nation be substantially altered? No. Will it adversely affect the delivery of governmental services? The answer is no. It's not blocking the street and everything else. The swimming pool and all the cars might be blocking it across the street from the guy who objected. But as to this property, no, he pulls up, everything's on that property. Did the owner purchase the property with the knowledge of the zoning restrictions? It was deeded to, or granted to him, or left to him by his father. His father, at the time he had the property, felt it was buildable. It was not buildable. The lot's only 1.25 acres. So while a public or commercial campground has to be at least 10 acres, we've already said that. Also, if you look at the campground definition in there for the commercial, it says it has to be, the entrance has to be on a main road. This is not a main road, this is Fay Drive. Can the applicant's predicament be feasibly resolved through some other method than a variance? The answer is no. It's a non-buildable lot. He pays taxes on it every year. He gets the benefit of paying a few $100s of taxes for nothing. Will the variance preserve the spirit and intent of the zoning resolution, and will substantial justice be done? The answer is yes. This is R4, riparian. Think of the nice creek, the ravines, the animals, all the nature. The driveway is on the flat part of the property. It actually enhances the stability of above the ravine. And he did not encroach into any way of the down part on the ravine. You've got people up and down the street, including the lady next door, but also at the bottom of the hill, a lady who would be affected by any pollution. Holly is her name. It's one of the 11th letter or something in there, but she fully supports the use of the property in this manner. So you've got a longtime resident, the whole street supporting him, except for one person. And that one person, he moved in 2 years ago, and what did he do? He built a swimming pool, and he's got the street blocked with cars. I think that Mr. Morano deserves the consideration of this board. Appreciate it.
Thank you.
I think we keep it short.
Yep. Any questions?
No questions.
No questions.
No questions?
Okay.
All right.
We'd ask
Thank you,
for it.
Mr. Ray.
Thank you.
Anybody speaking for or against? All right, come on up. Have you been sworn?
I have.
Okay, and state your name and address.
Lori Gunther, 10581 Habit Court, Concord.
Okay, hi.
Hi. I know we don't have to get with every detail here, but I'm a grandma of 21 grandchildren, and I have 2 great-grandchildren included in that total. And when I think of the opportunity to bring my grandchildren into an area like that and have a place for them to play, that they're safe, they're with a grandfather and parents or whatever, I think of the other side of the coin. They could be who knows where these days. And I just think, it's a grandmother's heart or whatever, but I just would like to say I'm totally for it. I'm not sure I understand the whole campground thing, but, that's just what I wanted to say. Thank you.
All right, thank you. Anybody else for or against? If not, I'll go ahead and close the public hearing, and I will entertain a motion.
I will make a motion to approve the variance application 2024-154 for Jeff Moreno, who is requesting the use variance from section 1502 to keep the existing driveway and fire pit and allow for the parking of his RV and sleeping in the RV for a few weekends during a period of May 1 to September 30th, where said use should be not permitted use. This is for the property located in Fayetteville, being the parcel number 088-015-0-0-012-0.
Second?
So moved.
All right, discussion.
I mean, as long as he wants to be there between May 1st and September 30th, good camping time. I think he improved the area. I'm a little worried about that offshoot that the GIS might be off where it looks like the driveway's off in the neighbors, but I don't know about that. But yeah, I think as long as it's only Jeff there. And
All right, so are you proposing conditions?
yeah.
Okay, so why don't you then go ahead?
Oh, sure. So conditions is that the variance is limited to Jeff Morano.
Okay,
So should he sell it, it goes back. So no future property owners.
limited to current owner?
Current owner, Jeff Morano.
Okay.
Only
Next one?
Only one RV parked at a time let me try that again. Only one RV parked at a time on the weekends between May 1st and September 30th. And as long as he doesn't build any additional structures or
Okay.
buildings on there, groovy.
All right, anyone?
I'll second that amendment.
I might have a question. So weekends. So let's say it's the 4th of July and the 4th of July is on a Monday. Do you want to say no more than 3 consecutive nights
Sounds
in a
great.
row or
Long
4?
weekends are- long
I'm just
weekends are-
trying to give a little
What if 4th of July is on a Wednesday?
Yeah.
or a Tuesday or
Right, so
something.
I guess how many days, no more than so many.
I
No
would-
more than 3 consecutive nights?
No more than 4 consecutive. I guess I just want to also make sure that there's not going to be storage of an RV
Yeah,
there.
he's got to.
So that's why I'm saying like 3 or
Okay.
4.
right.
I'm
Yep.
flexible on that.
Cool.
So are we
All
doing
right.
no more than 3 or no more than 4?
Keep an eye on this.
No more than 3 nights or no more
I
than 4
would say
nights?
no more than 4 nights.
Consecutive nights.
Yes.
Sure.
Okay.
All right,
Now, the question is,
go ahead.
we have to make sure the applicant agrees to that.
Right, that's my next,
Yep.
that's gonna be my, Mr. Ray, Mr. Morano?
Mr. Brown,
Yeah,
just say yes.
do you agree to those
Yeah, that's
conditions?
more than fair.
Okay.
That's all I ever
Got
wanted.
it.
All right, so
Should we have
then,
him say his name and address for the record that he's been
Yes.
state your name and address for the record.
Jeff Morano, 890 Madison Avenue, Painesville, Ohio.
Okay, do you understand the conditions?
Yeah, from
Okay.
May to September, no more than 4
September.
consecutive nights.
Only you, no
Well,
other owners?
You mean my RV?
Yes.
No,
Yeah.
only you owner. No, the person who buys your property, if you sell it, can't.
Oh,
do
yeah,
that.
yeah.
Okay. All
The
right,
RV must be removed after he's done camping.
right.
I'm not leaving
That's
it there.
implied, right.
It won't be there when I come
Bad
back.
neighborhood.
Yeah, it's really bad.
Okay, thank you.
Okay, thank you.
All right, with those conditions as stated,
You're gonna have to amend your motion That was not included in the motion. I'm not even
Okay,
clear on what the
let's
conditions
go
are.
ahead.
We should do the
Todd,
whole-
you amended
Yeah.
that, right?
Yeah, let's amend the motion
You said do
to
a new
include
motion
the
and
following
amendments?
conditions.
I would do
Okay.
an amendment with a condition.
Limited, I hereby amend a previous motion to include the following conditions. The variance is limited to the current owner. The variance applies to only one RV at a time. The variance applies between May 1st and September 30th for no more than 4 consecutive nights. And no additional buildings or structures shall be constructed on the lot. Okay?
As well as not to future subsequent property owners.
I said, that's the first one I stated. Okay, so having stated that amended motion, do I get a second?
Can I clear one thing up? Or just one question, when you say not to the future, we're talking about the RV thing. I don't have to take the driveway out if I
No.
sold it, okay?
No.
Wait, say that, I'm sorry, I actually am confused. So I thought the condition was that, in other words, if this property were to be sold by Mr. Morano, transferred to somebody else,
Right,
the use goes away.
Correct.
correct.
But he doesn't have to pull out the driveway. The driveway's there.
The driveway, the fire pit, the picnic table stay, it's the RV use.
Right, the RV
I
is,
think we
yeah,
need to be clear. Yeah. Because
I mean, the driveway can stay.
it was clear.
There's no use now, right? So what's the driveway?
I think from the clarification is if he sells it, the driveway stays. Like he doesn't have to rip up the driveway and put trees back.
They can cook s'mores during the day.
Yeah, they can do whatever they,
Hot dogs during the day.
they just
Go
can't,
visit Big Creek.
they just don't, they don't get the benefits of the variance. Okay? All right, having stated the amended motion, do I have a second?
Second.
Okay. Heather, want to take a vote?
Sure. Any discussion, or you guys are?
I think we
I-
just did.
Possibly have a discussion?
Oh, you have further discussion?
I do. Is that clear enough of what we are stating in our
I'm clear with it. The applicant's clear with it.
legally? Is that clear enough? Or do we need to rephrase the way we've said what we're trying to intend?
No, I think the conditions are there.
Thank you. I have no more discussion.
Okay, Heather, you want to take a vote?
Sure. Mr. Sweeney?
Yes?
Ms. Garkar?
Yes.
Mr. Rowan?
Yes.
Mr. Falkowski?
Yes.
Mr. Bowling?
Yes.
All right. Thank you, Ms. Morano. Thank you, Mr. Ray.
Thank you, guys. Thank you all the people who are waiting.
All right, our next matter on the agenda is variance 2024-155. Kay Deegan, if I said that properly, is requesting a variance from section 15.03A2 to allow an existing barn to be located on a lot without a principal building. Hi, you may proceed.
Hi, everybody. Kay Deegan, 7393 Morley Road. And I have been sworn in.
Okay.
Is it my understanding that you have the map
Yes.
and the boundary
Yes.
Yes.
Yep.
survey? Okay, good. And my letter is in front of you too?
Yep.
All right.
Yep.
So it's been a very long evening. I've already
Thank you for your patience.
forgotten what I'm going to say. Got so involved with everybody else's issues. I'll try to summarize this. We're seeking a variance to the section 15.03A2 standard that accessory buildings should be located only on lots with a principal building. The accessory building in question is a 20 by 40 pole barn. It was built in 1970. It's in good condition, and it stores the equipment used to maintain our fields and woods on both our Morley and Hermitage Road properties. We wish to tear down the principal building located on the Hermitage Road property, but we need to keep the barn. And so at this point, it might be helpful if you take a look at this map. And to the left, I believe everything's outlined. You can see Morley Road, and you'll see our roughly 4+ acres. And then we also have a 2-acre lot right next to us that is on Kellogg Road. And if you go all the way to the rear of that property, you'll see that it joins the property I grew up on Hermitage Road. So it's sort of a unique setup. And if you read my letter, it's been in the family since the early 50s, and we strive to keep it that way. You can also see on that map the 3 acres that we gave to our son who is here tonight. And they just completed, I don't know if you've gone down Hermitage, they just completed a nice little home there. So, you can also see on the white map here, the buildings. You can see them on the colored map. You can see the house on Hermitage near the pond. And then if you go back toward where my son's house is, you can see the barn very faintly. But on the white map, you can see it better. I think I have it circled in red. The house on Hermitage that we wish to tear down. And then it's labeled existing shed.
I don't think we have
I don't think,
that.
yeah,
one.
I don't think we have that.
Heather, did you have?
We didn't submit that, but I thought
Did,
Did that one day I came. If you want
maybe if
to
you
look
just
at
point
this.
out, point out
Yeah,
to us on this large.
it's
where would it
very
be here?
faint on Hermitage.
So Hermitage is here.
Yeah, and here's the pole barn.
Okay, so right towards the blue
It's
line.
This
Oh,
right
I see
here?
it now. Yeah, I see it.
So this thing right here?
Yes.
Yeah, I see it.
So
It's pretty blurry.
So that's what's gonna remain?
It's actually
So here's the
almost easier to
house.
see
Right.
on that
And-
one.
Yeah.
I believe that's the
Go
pole
zooming
barn.
in.
You want to clear down?
Yes.
I know exactly. I drive by all
Okay.
the time.
That's what's gonna remain?
We wish to keep
That
the
barn.
barn.
Okay.
Because it has all the equipment in it.
Gotcha.
Um,
But that house in the picture? That's coming down?
We'd like to.
Okay.
And
And I believe that's where the variance comes in, correct? Because
Yeah,
now
Right.
you have an accessory building that's an accessory to nothing, essentially.
Right.
Exactly. So my mother passed away in the fall of '22, and I inherited the property, which we want to keep. Nobody in the family wants the house. My dad built it in the '50s. It's in deteriorating condition. My husband and I don't want to renovate it to sell or rent. We simply want to keep the property and return it to its natural setting that'll go along with all the other property that's there. Without the variance, well, I'll get there later. We just want to keep the property, raise the house, and let it be a natural setting. However, the barn is essential for equipment storage in maintaining both our property on Morley, because there's a field and woods there, as well as the bigger field and the woods on Hermitage. And in my letter, I addressed what I felt were relevant Duncan factors to justify the practical difficulty facing us if the pole barn cannot exist without the house. So if you'd like to look at page 2 of my letter, I don't know if you want me to go through those orally or...
I would think for the record, it would probably be beneficial. So if you could go through that.
Certainly.
Yeah. And what's the total acreage?
Including ours on Morley?
Yeah.
Or the Hermitage? Hermitage property,
Including everything.
All the Deegan stuff.
Yeah, all the Deegan property.
13 on Hermitage, and then roughly 7 on Morley, so 20.
Okay, all right, thank you. Yeah, that would be a good idea if you went through those factors for us. And tell us where you're referencing.
Page 2 of my letter
Okay, got
that
it.
accompanied the application.
Got it.
So, number 1, can there be a beneficial use of the property without the variance? And I don't know if I understood these perfectly. I know Heather couldn't coach me, but I said our goal of keeping the property undeveloped is what we perceive as beneficial use of the property, and this goal cannot be achieved with strict adherence to the zoning standard. Without the variance, an undesirable option is to leave the old house to deteriorate on the property in order to keep the necessary barn. And I live across the street from a house that is not lived in right now, and it's really hard to watch it just go downhill. You might know that house on Morley, the old cat house.
Kitty City.
Kitties. Number 2, is the variance substantial? And I felt the variance request involves a barn already there and would be the minimum necessary to continue use of the property. Nothing would change except the removal of the house. Number 3, will the essential character of the neighborhood be substantially altered, or will adjoining properties suffer a substantial detriment of the variance if granted? And we felt that granting the variance would have no effect on any adjoining properties since we own the surrounding undeveloped area. Keeping the fields and woods maintained as we always have continues to enhance the rural character of the neighborhood. It's one of the only open pieces of land left on that road. If granted, the variance would allow us to keep the equipment barn in order to seamlessly continue maintenance of the property. And also noteworthy is that the barn is so near our son's new home. And I've got a couple photos I thought might help you.
Thank you.
You can see the pole barn in the background there where his garage is to the right. If the variance is granted, this barn would not be a lone structure on unoccupied land. The close proximity to his house allows for convenient monitoring of the building and its contents. Can the problem be resolved by some manner other than granting the variance? Our predicament presents us with no keywords reasonably feasible and practical solution through methods other than a variance. Will substantial justice be achieved through the variance? And this practical difficulty is peculiar to our property and is not shared by neighboring properties. So in conclusion, we've explored for months all options, and strict adherence to the standard results in practical difficulty if a perfectly functional pole barn cannot remain without the house. There seems to be no reasonably feasible and practical solution other than through a variance.
Thank you.
So I thank you for your time.
Thank you. Questions?
I have a question. Did you explore the option of shifting the property lines of your son's property, and why was that not an option, just out of curiosity?
Time, there was a time factor. Cost, property taxes, the 3 acres with the new house, that wasn't feasible. We thought at a later date maybe we could have a new boundary survey, but that was explored.
And if you want to speak, if you want to come up and state your name and address.
Yeah, have you been sworn?
Yes, I am.
Okay.
My name is Craig Deegan, and I'm at 7406 Hermitage Road, which is the new house that was built. The main reason for not having the barn on our property was the location of our driveway. We used an old service drive that my grandfather had used for his business. He had a dog trading business there for many years. And our current driveway, we wanted to use the old service driveway, so that's what we did. And the property line was just to the if you're looking at Hermitage, it's to the right of the driveway is where the property line went. So we would have had to add a 4th acre onto our lot split, which of course would be more money in property tax. And
Gotcha.
I guess I was just looking at it from a, you've got the property line here, and just like shift it over, keep it 3 acres, shifting it over, but again, just
Yeah.
exploring options, understanding.
I
your
had a
predicament.
feeling you'd ask
So
that.
I
Believe
just want
me,
to make sure we understand.
I've got a paper that lists all the options we've looked at, and it's sort of complicated
A lot
and
of it
expensive.
also was the location of where we wanted our current house to be put on the 3 acres. Where it's built is it's up higher on a little mound instead of the low spot. So our house is pretty much right in the smack dab middle of the 3 acres, and which is where it would be the perfect location because of the hill there.
I don't have any other questions.
Okay,
at this time.
anybody else?
I do not have any questions.
All right, Todd?
Nope.
All right. All right, thank you very much.
Thank you.
Is there anyone else speaking for or against?
You know, I also, this is Craig Egan again, 7406 Hermitage Road, I have been sworn in. I just wanted to say, since our new house is in such close proximity to the barn, it would never be left unattended. I always help my parents with upkeep of the field and everything. You know, the barn houses equipment in order to keep up with the fields and everything. It would never be left unattended.
Okay. All right, thank you.
Yes.
All right, so if there's no one else speaking for or against, I will entertain a motion. Ashley?
Are we closing public forum?
Is there anybody speaking?
If there's no one speaking yet, I will close the public meeting. Thank you. Chair?
For or against? Did you have to ask if anyone was speaking?
Yeah, I
She
did.
did. He did.
Sorry.
I would make a motion for approval of variance application 2024-155 by Kay Deegan, who is requesting a variance from section 1503A2 to allow the existing barn to be located on the lot without principal building. It's for the property located at 7440 Hermitage Road, being parcel number 08-A-027-A-00. Sorry, 00-008-0.
Second.
Any discussion? If not, Heather, you want to take a vote?
Sure. Mr. Sweeney?
Yes?
Ms. Garkar?
Yes.
Mr. Rowan?
Yes.
Mr. Falkowski?
Yes.
Mr. Bowling?
Yes.
All right, thank you. Good luck with everything.
I'm glad that was easy for you.
Thank you. I was hoping it would last a little longer.
Till midnight?
Yeah.
All right, so on to our next matter, which is a conditional use permit application 2024-28. AMP Services LLC is requesting approval for a conditional use permit to operate an adult daycare center in accordance with section 13.05 and 13.08. This is for the property located at 7757 Auburn Road, Unit 6, and being parcel number 08-A-020-000-036-0. Hi, have you been sworn?
Hi, I have been sworn in. Name is Matthew Hampshire. My address is 30417 Forest Grove Road, Willowick, Ohio. I am the owner of AMP Services LLC. I'm here to ask for a conditional use permit for the site at 7757 Auburn Road, Unit 6, for an adult daycare center, right? So let's talk about what that is. Okay, so myself, I work for Lake County Board of DD, Developmental Disabilities Deepwood, right? Lake County Board, we serve about 780 folks in Lake County who have a developmental disability, okay? Out of those 740, 600 of them are 18 and plus, right? So they're adults. So you think of DD, you think of somebody with Down syndrome, somebody with autism, right along that line. A lot of I'm gonna reference our folks as somebody with a DD, right? So somebody who typically has a disability, when they graduate from school, 18, they have the leisure of staying until they're 22, right, in law. So when they graduate from school, what's next, right? A lot of the folks who are on the higher end of the spectrum can work, right? They go get a job out in the community, McDonald's, Home Depot. I have a gentleman who works at Lake West Hospital, well, was Lake West Hospital. Anyhow, the other folks who might not have this skill or are trying to gain the skill, of interpersonal skills, taking demands from a boss, right? Learning those skills, they go to adult day center, okay? So my goal here is, well, let me back up here. We have 17 adult day centers in Lake County. Majority of them are in Menor, off of Tyler Boulevard. We have a handful in Madison. Painesville has a couple. Willoughby has a couple. There is not one in Concord, so I'm looking to open the first one here. Basically, the day-to-day operations of what we're looking at is we're building we're building independent skills, okay, with the folks. So we're trying to get them engaged in the community. So my goal is to do volunteer work, okay? TriPoint has a good volunteer program that I'm trying to get set up with over there. Okay, and 68 Hours of Hunger, if you guys have heard of that. It's an organization that is based for the school systems. They collect food. Friday is the distribution days where the school systems come to there and they take food back to the school systems to give to the kids who might not have food Friday at 3 o'clock all the way till Monday morning, 68 hours, right? So my goal is to do volunteer work there as well, help stack the food, right? Help my individuals, this building I'm looking at, Randy is the landlord, Mr. Vivian, I believe his last name is. We've chatted about this, he's on board with it, he's gave me, I think you guys might have in your packet a letter from him approving it as well. So my idea for this is to have at maximum capacity, you're looking at 12 to 16 individuals in this building. Okay, not all at once, because the goal is to go out and do volunteer work, right? Myself, I have one staff member, one employee that is coming with me as well, okay? So the goal is to kind of get groups of 4, right? We go out and we do volunteer work. We help expose the DD population to integrated, right? To the general population. See if they can build relationships, possibly earn a job, right, through volunteer work. As far as emissions for the building and for the company itself, there is no emissions. There's no gas emissions. There's no light pollution. There's no extra noise. We're not going to be outside. I mean, we're not going to be in the parking lot. If you guys have drove past the 7757 Auburn Road, right? When we go out, we're going to go to the parks around here. We're going to go to the I think it's the corduroy, the path. I'm sorry, I don't know. Not too familiar with the area.
The Greenway?
Yeah, there you go.
The corduroy.
Yeah. The Greenway. So we're not going to be outside in the parking lot hanging out. There is a little area over there for lunch breaks that I saw. They have a bench or two there. I kind of scrambled there, but that is a general synopsis of what I'm trying to open up there.
Okay. All right. Thank you. Does anybody have any questions?
I have no questions.
So,
all right.
Just again, 1305 is for. Other 1305.
That's the general criteria.
General criteria. 1308 has to do with the security fence.
1308 are the specific conditions that you should take a look at related to the adult adult daycare.
1308.
Will there be food service in there?
No.
No. What? I mean, I think that's the old Time Warner office. That was Spectrum office that was there. So
the gentleman, Randy Vivian, shared that it was a pharmaceutical place before, maybe a medication storage unit. It is current vacant, so there's no use in there as it is.
How would it be set up inside?
It's going to be set up as business supplies. You're thinking office supplies, right? So it's going to be a little bit of office supplies, and then essentially like your living room would be, right? So I'm going to have a couch, I'm going to have some TVs, I'm going to have some activity tables, so we can learn basic skills, counting money,
What are your hours?
So the hours, the program hours are from 9 to 2. Okay, I will be doing transportation as well. So you're thinking 8:30 drop off, right? You're thinking unloading, dropping off between 8:30 and 9.
Okay.
And then when you're leaving the program, you're looking about 1:45 to 2:05 for leaving the program.
So I think there was a question about like the eating area. There's a common area outside of there, and I think that's where the question came in about 13H with the possibility of a fenced area and that. So I guess is there any concern from zoning about that, or since it was referenced?
I think the number one question
So-
Well, I
is,
think, Heather, I think
is there
this-
any outdoor activity coming?
Brady, correct me if I'm wrong, but this application is to determine whether or not the use is an approved use through the zoning text.
I
Heather,
think,
right?
well, I think he's asking for conditional use, which is
Right.
permitted as a conditional use in this zoning district. But in order to, you still have to look at the general,
Okay,
standards for any conditional use. And then in addition, the specific standards that apply to the adult daycare.
okay, that answers my question. All
So
right,
is there going to be outdoor activity at the facility?
So for referencing back to the fence is only for daycares for children.
No. All outdoor activity areas for child or adult daycare centers shall be adequately enclosed by a fence at the height appropriate for the Board of Zoning Appeals. An entry gate shall be securely fastened. Such fences shall comply with other applicable fence requirements set forth in section 3810 and the landscape and screening requirements with amendments and dates. So, will there be outdoor activities at that facility?
No.
Any reason other than going in and out of the building that
Correct.
Other than the common eating area outside, and I guess the concern, would there be any concern there?
No.
Is there a common eating area outside? Did I miss that?
There's 2 benches that are in the green space in the middle of the complex, I guess you can call it.
So that would be just
It's really anybody that
your
uses that building.
clients using public property. That's not
Or common property.
okay.
Common
Yes.
element to the association.
And so I guess I'm just making sure that there are no concerns from anybody that, since it was brought up in the staff report as a possibility, but there's no outdoor activities outside of possibly
Correct.
Yeah, I know, that's
common
the biggest
area.
one.
So I guess that answers my question.
And you guys have looked into going through all that then real quick. You guys have looked into protection and safety for everyone who will be in there with the building that is currently built. That
Yes, I had to assure $1 million business policy insurance. I'm approved through DODD, which is Department of Developmental Disabilities, and ODM, Ohio Department of Medicaid. They have to sign off on approval. They will do a building site inspection as part of the approval process as well.
I have no further questions.
okay. Anybody else? All right. There's no further discussion.
Is there anyone else to speak for or against?
Is there? No, we already. Oh, yeah, is there anyone else here speaking for or against? If not, I will go ahead and close the public meeting. And entertain a motion from our new chairperson.
I'd like to make a motion to approve the conditional use permit application 2024-28 brought to us by AMP Service LLC, which is requesting approval for conditional use permit to operate an adult daycare center in accordance with section 1305 and 1308. This is for property located at 7757 Auburn Road, Unit 6, and the parcel number being 08-A-020-000-036-0.
Second. Any discussion? All right, if not, how do you want to take a vote?
Mr. Falkowski,
Yes.
Mr. Rowan,
Yes.
Ms. Garpar,
Yes.
Mr. Goling,
Yes.
Mr. Sweeney.
Yes. Congratulations.
Thank you, guys.
Okay. All right, our next matter before the board tonight is variance application 2024-156, EA Architecture and Design, Inc., on behalf of Pacific Bells LLC and property owner Madison Real Estate Developers, Inc., is requesting a use variance from section 16.07E2 to permit a counter service restaurant with a drive-through. This is for the property located on Crowell Road and being parcel number 08-A-019-B-00-002-0. State your name and address.
My name's Russell Arbuckle. I'm with EA Architecture and Design. I have been sworn in. My address is 1906 Willow Bridge, Normal, Illinois.
Okay, you may proceed. Thank you for your patience.
Sure. As you stated, this is a variance application. The proposed location currently is a portion of a lot that has the key bank on it, right on Crowell Road. And it's vacant, green space lot right now. Does have a driveway on it, a gravel driveway on it. It's the only thing that's there now. The issue with the variance, this is in a PUD, and a restaurant with a drive-through. A restaurant is allowed, a sit-down restaurant is allowed, but a restaurant with a drive-through is not allowed without variance. So, to get to the nuts and bolts of the criteria, may the property be used for any other permitted use in that zoning classification district? That's difficult. In any commercial property, it can be used for any number of things, so that's difficult to say anything but yes, it could be used for something other. But this lot has been vacant and unused for a period of time, so the proposed use is currently the highest and best use available at this time. Is the requested use for the variance due to unique circumstances particular to the property and not to the general neighborhood conditions? I would say yes, that this parcel is in a commercial corridor, but it's in a residential PUD, residentially zoned PUD. And much of the PUD and surrounding properties and parcels are already light commercial uses. That's a little bit of a unique circumstance. Will the essential character of the neighborhood be substantially altered, or will adjoining property suffer substantial detriment? I believe no. Granting the variance would have no detrimental effects on the neighborhood. Is the problem self-created? No. The drive-through is a Taco Bell corporate essential element. It's not something that Taco Bell's or the owner of the property, either one, have much of a say in. Will the variance adversely affect the delivery of governmental services? No, it will have no effect on any of those things. Did the property owner purchase the property knowing of the zoning restrictions? That's unknown to me, but Pacific Bells is actually a tenant entering into a leasehold agreement. And they entered into the leasehold agreement without prior knowledge of the zoning restrictions. Can the applicant's predicament feasibly be resolved through some method other than variance? Now stated the drive-through is a Taco Bell corporate element, essential element. And will the variance preserve the spirit and intent of the zoning resolution with substantial justice be done by granting the variance? I believe yes, it will allow establishment of a viable business on an otherwise vacant parcel while maintaining standards consistent with those priorly established in that PUD. So with that, I'd entertain any questions about the variance.
Okay, thank you.
How many customers does Taco Bell serve average on a daily basis?
I can't answer on a daily basis. I'm the architect and not an operations guy. The typical high hour output expected for this location is below 35 customers per hour in their peak hour. And the only reason I know that is that's how they establish how many kiosks they have to have at their front counter. So we have to have 3 kiosks because we're under the number for
What's the peak hour?
lunch hour, of course.
Lunch is peak hour.
Yeah.
Okay.
I noticed there was no traffic study attached. So normally with a drive-through, the main concern is drive-throughs create cars. Cars on Cryle already are becoming problematic as the corridor grows. So a little chat GPT today, they told me on a good day 350 cars, on a really good day 500 cars. So my concern is that with a drive-through attracting cars, of course we have 44, which is an exit off of a major interstate, which hence the attraction for Pacific Bells, I would imagine. I'm interested in seeing the Pacific Bells input on traffic study and its impact on Cryle Road.
Traffic study would be, is warranted, I think, but it is, it wasn't my understanding that was a part of this application. It was for the zoning certificate, would be the thing for that, is my understanding, so. We'd be happy to provide one.
Has it happened yet?
It has not.
Does the county require a traffic study, or is that a requirement of any agencies they would need to get approval from, or is it a nice to have?
So the zoning commission during site plan review could request some kind of traffic study, but also the Lake County engineer could, because that does impact their county road.
And we plan to have one done as part of the next month's proceedings, presuming these two proceedings go forward.
And to piggyback off of his question, I think the biggest concern with this area is that anybody coming from the freeway would turn left to get in there from 44 and then have to turn right. To get back on 90, they have to turn left. There's no way to get on making a right without doing a U-turn in private property, essentially. And that's pretty common right now, and I've seen some illegal U-turns in that area too. So I think along these lines, I think with the drive-through, and I don't know if this is for us to put on as a condition or if it's something that the zoning commission would do, but I think, you know, making sure that we have very obvious signage. There are signs in some of those areas that tell you to go left for 90, but I think that would be something that we would want, is that as people are exiting, they know that if they need to get back on 90, it's a left turn. And that, again, I don't know if that's for us, but I think that would be a condition that I would want to put on there.
You certainly can. Sure. Ask for a traffic impact study, you could ask for more information.
Yeah, the traffic impact study, like I said, that's on the agenda to have done. The signage, I would have to know more about where that would need to be placed, whether it would be on the parcel in question, or whether it would have to, we'd have to get an easement, put a signage elsewhere, or if it's on governmental property.
And I mean, not that people are actually going to follow it, but at least it's
Understood.
there.
Yeah, no, I understand. I drove it today.
Yeah.
I went there today to the site again for the second time that I've been there, and so I fully understand your concerns about that intersection right there.
Yeah, and I think that's where the stacking comes in, because I know Starbucks can back up onto Cryle even after they made adjustments. So I think the concern is because you even have a shorter runway there to the intersection, that, you know, we want to make sure that there's adequate stacking.
This, I mean, the stacking that we have proposed currently is more than we would normally propose. Typically, Taco Bell standard is an 8-car stack, with the mini board being at the 5th car. We propose, I think the township requirements are a 10-car stack.
Yeah, and I see that on the.
So we're showing that, but there's also a future, it's not shown on the plan, it's a second drive-through lane is an option. We're not showing it there because we're not proposing to put it in right now, but it's available if it becomes an issue that we have to have, be able to move more cars through faster.
So would we need to get a second variance for a second drive-through, or is it an approved?
My understanding, it would be an approved use, but it would still need zoning certificate to add, I would think, to add it. And that would be, I mean, the intent is to do that down the road or at request. It's not to do it now.
I have a question that might be for Heather. Hopefully, can you answer? Obviously, a traffic study is going to happen at some point throughout one of the multiple layers here. Is there a point within the traffic study that a traffic study, if we say yes, we're cool with a drive-through, that's fine. They go get their traffic study done. The traffic study, is there a point that says there is too much traffic and we will not let you put a drive-through in because there's too much traffic?
I don't think that's what a traffic study would tell you. A traffic study would likely tell you whether or not Cryle Road can handle the traffic and any other lane improvements might be necessary, and things like that.
So there's another stopping point, I guess, is where I'm
Well,
getting.
not really, no. I mean,
If we
there's
say
always
you can
ways
put
to
it-
work it out. You
Well, if
add
we
a
say we
lane,
can use a
know.
drive-through, you can put a drive-through in there.
I mean,
And the
traffic-
traffic study says it's too crowded.
Well, traffic studies were done for Cryle Crossing, where Starbucks and Chipotle are. I mean,
Yeah.
they don't anticipate necessarily backups on drive-throughs, is my understanding.
Right.
That's not what they're looking for, and maybe,
And if I may, in that same general area, there's already across the street anyway, there's a McDonald's across the street with drive-through. There's a bank, the Key Bank has a drive-through lane, and there's a 24-hour restaurant immediately adjacent. So,
Huntington Bank's got a drive-through.
what's that?
Huntington Bank's got a drive-through.
Key Bank does.
Key Bank there.
So does Key Bank, and then so does the other,
Yeah.
the next bank down further towards Sunoco.
Yeah.
They all have
100%.
drive-throughs.
So, yeah, they all have drive-through. Granted, now they don't have a mad rush all at lunch hour or dinner hour or whatever. So it is slightly different. Maybe at 5 p.m. when everybody's going, wants to beat the rush before they close at night, they might have a mad rush and that sort of thing.
What are the hours anticipated? I guess what are the hours that they're proposing that the drive-through would be open? I don't know if that's in your purview or not.
It's subject to change, but they're usually open late. I know, 2 a.m. or something, or whatever the requirement to be able to close, because they have the Taco Bell has their whatever they call it, fifth meal or whatever they call that. Promotional. What's that?
Live Mas.
Yeah.
Right from the border,
And
etc.
I don't know. Do we have a
So-
restriction on hours for restaurants?
I mean,
don't know if
the hours really, the late hours don't affect the traffic because the bank's
Right.
closed and the other things are closed. So the hours are typically usually limited when it is an issue of noise. And in this particular case, we have nothing close by. We have behind us, there's tanks, storage tanks, gas storage tanks. There's the overgrown waterway, whatever that is. I think that's waterway behind the Waffle House. Waffle House is open 24 hours. And that outlot behind us has a natural gas, I think it's a natural gas pump on it. And then, of course, Key Bank would be closed at the later hours. So I don't see our traffic conflicting with traffic otherwise there, except perhaps during lunch hour, when Key Bank's perhaps has a run on their drive-through and Taco Bell might have a run on their drive-through. So, and they're really, Taco Bell and Key Bank are the only ones that use that crowd access right there, because it's got a shared drive off of Crowell Road right there. Key Bank and Taco Bell will have the same shared access right there.
I have no further questions for him.
You what?
I have no further questions for him.
So do you know how many Taco Bells are within a 6.4 mile radius of right here?
I do not know because I'm geographically challenged of how far away the nearest Taco Bell is.
I'm geographically challenged here.
Two.
Google says 5. There are
Okay.
5 Taco Bells. There's one in Chardon, a couple in Menor, one on Menor Avenue, one in Diamond Center, one over in Painesville, and the 5th one closer to Willoughby. But either way, my question is, I guess, are we a good, our job is to look out for the future of Concord Township, and is approving this in the best interest of Concord Township, given the potential for the traffic that you may potentially receive as the result of a 2 a.m. drive-through off an interstate?
So I think that would be a conditional use question, not a drive-through question.
Right.
Just
And
for the
hence-
record.
Hence the conditional use, right?
I think that's a conditional use question.
Yeah.
The next thing that we're talking
Yeah.
about.
I tend to merge them together.
I know you do. I have no further questions for the applicant. I don't know if there's other people for or against.
No questions. Anybody? All right, thank you, sir. Is there anybody here speaking for or against, or just spectating? All right, if there's nothing further, I will close the public hearing and entertain a motion.
I will make a motion to approve the variance application 2024-156 of EA Architect and Design Corporation on behalf of Pacific Bells LLC and the property owner of Madison Real Estate Developers is requesting the use variance from section 1607E2 to permit a counter service restaurant with a drive-through. This is for the property located at Crowell Row and being parcel number 08-A-019-B-00-002-0.
Second. Discussion?
Yes. I think we've had multiple lengths of discussion on the property directly across the street, whether or not a drive-through should be permitted in this area or not.
What?
Directly across what street?
This is right.
Between
It's
Waffle
between
House
Waffle House
and
and
Key
Key
Bank.
Bank.
Key Bank already has a drive-through.
Correct.
Right.
And isn't this right here on the other side, right near the area of the Victor property that we
No.
just
No.
denied?
No.
So I'm looking very
No.
geographically challenged.
No, this is like
Yeah.
right.
Yes.
Almost up by Red Hawk.
Before we get
It's
into
Almost
all
up by
the way
Red
at the
Hawk.
other end
Yeah,
of
this is
Crowell.
like Waffle House and Key Bank.
You know where Waffle House is?
I do. Okay.
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 Right next to Waffle House.
Okay, that was my number one.
You are geographically challenged.
Very
You did not
geographic.
lie.
I'm looking at this like.
All right, any other questions?
I would
For
just,
discussion.
again, my only condition that we would have to get approval from the applicant is just having signage about turning left for 90. And I just want to make sure we include that. We've included signage conditions for crosswalks at Starbucks that I didn't think, I wouldn't have done it for that, but I don't see a problem with it if you guys don't.
I'm not inclined to require that as a condition. So if you want to take a vote on the condition, let's do that.
I'm just asking.
I'm struggling with the drive-through, just in general.
Wait, what?
We're talking about the drive-through.
We're talking about the drive-through.
Yeah, we're
and as
talking
a
about
condition, as a condition
To
for
turn
the
He's fine.
variance. Or I can.
Does anyone else want to put a condition on this? Other than
No.
Davey?
That's fine.
All right, so let's move forward.
I'm
Yeah.
fine with that.
I think that might be addressed though at a later stage.
Okay.
Just as an aside. Any further discussion?
I think Key Bank has a drive-through. It's on the parcel directly next to it. I don't see how it would be appropriate not to approve a drive-through for this parcel. And then
I think it's apples and oranges though.
A bank versus restaurant is completely different,
Mm.
and I.
I mean, I have, to Davy's point, sat in the drive-thru at Taco Bell at 2:00 in the morning, right? He
Can't
knows
say
what I'm
that,
talking
but-
about.
see, I would have thought those were the
With
peak
how many in the
hours.
queue? With how many in the queue?
Oh, you'd be amazed.
Go to East
Well,
Cleveland on
how many in the
any
queue?
Saturday at 2
Well,
a.m.
Bowling Green was a long time ago, but I would say that we waited quite a while at 2 a.m.
All right, so at 2 a.m., the Waffle House and Taco Bell will have Crowell Road all to themselves.
Potentially.
And Sunoco.
Yep.
I don't know what I was thinking.
So I don't see that as being a problem.
I'm not worried about it.
I'm not worried about it. Anything else? All right, there's nothing further.
Why just say that?
All right, Heather, you want to take a vote?
Okay, sorry. Mr. Sweeney?
Yes?
Mr. Bowling?
No?
Ms. Garkar?
No.
Mr. Rowan?
Yes.
Mr. Falkowski?
Yes.
All right, you have been successful. We move on now to our final new business matter for the evening, conditional use permit application 1209-31 EA Architecture and Design, Inc., on behalf of Pacific Bells LLC, and the property owner Madison Real Estate Developers, Inc., is requesting to amend conditional use permit 1209-31 for a commercial center in accordance with section 13.05. This is for the property located on Crowell Road and being parcel number 08A-09-B-00-002-0. All right, Mr. Arbuckle? Okay.
Same project, same parcel. This is actually just to amend an existing conditional use, as I understand it. As I understand it, the original conditional use was set for a strip center business use. I believe something along those lines. And we need to amend that conditional use to allow for a restaurant. So specifically in regards to the general standards applied for conditional use permits, we offer the following. A Taco Bell restaurant we feel would be harmonious use in the district, as there is already an existing 24-hour restaurant and a bank with a drive-through service immediately adjacent, similar to what the Taco Bell would offer via, as Mr. Going stated, though, it is a little bit of an apples to oranges, and we talked about that earlier with the drive-throughs. The general appearance and design and construction is consistent with other facilities in the district and is of similar or same character. So I don't feel that would be out of character for the zoning district. The Taco Bell is certainly not a hazard, nor will it be disturbing to any other neighborhood uses. All Taco Bell traffic will be relegated to the Taco Bell lot, and the proposed drive-through is at the rear of the development, protected from primary views by the building itself and the adjacent outlot to the rear. The access to the facility we feel is exceptional, as was stated previously. It's directly off Crowell Road with adjacency to the local highway. Utilities are adequate and accessible. The development would require no additional public requirements that we know of at this date, though the traffic study may change that. The development would not create or involve any activities or conditions of operation that would be hazardous or harmful to the general welfare of the community. Proposed on-site circulation is adequate for fire and police protection, as well as safe and efficient vehicular circulation. The development is designed to minimize traffic congestion, putting drive-through traffic out of the way of all parking spots. Garbage enclosure is at the rear of the building and backs up as best we can make it back up to the one from Key Bank. Fully screened cement enclosed, or cement block enclosed garbage enclosure. The development improves upon current natural features by improving upon a vacant lot and helping to shield from view the storage tanks existing at the outlot to the rear. And the Taco Bell is expected to enhance other uses permitted in the district and the immediate vicinity. So again, I'm willing to take any questions the board might have.
No questions? Anybody?
No questions for him.
All right, anybody for or against? All right, if not, close the meeting and we'll entertain a motion.
You're doing so good at it.
You're good.
Hi.
We're very proud of you.
Thank you. I will make a motion to approve the conditional use permit application 1209-31 for EA Architect and Design Incorporation on behalf of the Pacific Bells LLC, the property owner, Madison Real Estate Developer Incorporation, in requesting to amend the conditional use permit number 1209-31 for a commercial center in accordance with the section 1305. This is the property located on Crowell Road and being parcel number 08-A-019-B-000-00-0.
Second. Discussion? If no discussion, Mike, want to take a vote?
Sure. What?
Oh, is there some discussion?
You don't want to go through the,
I think there should definitely be some discussion about
We should
this.
go through the.
I think the applicant went through them.
What,
If I'm not-
what are you
if I'm
suggesting
not
we go
mistaken.
that's fine. Did you, I mean, if you're just going to accept those, that's fine. I didn't know if you wanted to discuss this, the general.
But if anybody wants to discuss it,
Okay.
I struggle with everything was in comparison of a bank drive-through versus a eating drive-through, which I think is very different, as well as 24 hours no drive-through and close to 24 hours with drive-through, that it's hard to compare
It's a
to.
24-hour restaurant right next door.
It's hard to compare a 24-hour restaurant to a drive-through 24 hours. I think there's differences in
And I
how
struggle,
much is there.
although it's subjective, the definition of harmonious for me is just. I mean, I drive down Menor Ave and I see the Taco Bell. I'm like, yeah, great. I just don't see the harmonious.
How do you feel about the Waffle House?
Yeah.
I don't like
Is
it.
that harmonious?
No.
I mean, it's a business district.
I love that place.
Really? I'm more of a Sunny Street guy.
I love them all. They all have a right to be there. If they
Sure.
if they meet the criteria.
Right.
So if you want to discuss that, let's do it. Harmonious, you were talking about.
I struggle with whether or not do I feel the Taco Bell on Crowell Road does. I mean, I don't think it fits.
Okay.
As well as the hazardous or disturbing to neighbors. Like there's just a difference in
What neighbors?
the
What residents?
If you're referring to it as residents, okay,
Like from
but
Quail.
I'm also referring to more just the traffic on Crowell Road. Can we handle a restaurant drive-through right there? And would that be considered hazardous? Maybe not to people physically living there, so there's not one living that's touching, but neighbors just in general of
I guess
people that
I'm
are
just curious.
in the area.
I just want to know how much more will it add? And I realize that more businesses means more cars. I just want to know. I just would have liked to seen that on average a Taco Bell will bring in at this time of day. I mean, granted, we're not going there at 2 a.m., but if lunch is the big rush and lunch is from 11 a.m. to 3 p.m., you know, is this something that will negatively prohibit some traffic on Crowell? Now, we've seen the sheriff hiding out in the Red Hawk, catching the people doing the thing, you know, the turnaround that they're not supposed to do. But will that increase? Maybe, probably. I mean, will we get more people off of the interstate to come into Taco Bell? Well, that's kind of the idea. Why, I would guess why they chose the spot is because it's adjacent to an interstate.
Right.
I have driven through the Mtg's across the street at lunchtime and made a bad choice to eat. It's always a better idea than actually doing it, but still, it wasn't horrible to drive, like the wait, because, you know, they've increased the number of drive-throughs over there, but, you know, with 2 drive-throughs, if it gets that busy where they gotta pop in another drive-through over there to do double drive-through to get through, I mean, I don't know, but I just wish, I guess my subjectivity, I want some objectivity to help me, my brain kind of figure out the numbers, you know, like here's a restaurant, how am I gonna come through? I don't know. And right now I'm working on I don't know, and ChatGPT would told me 500 cars a day. So I don't know. I just kind of, I wish I had some more information to make an educated decision that what's in the best interest for Concord going forward. And if we're going to allow this, is it because we've done the homework and we've seen that the homework supported, it's totally cool to put this here because it's not going to be a gajillion cars. So banks, on the other hand, I don't know who uses bank drive-throughs. I've never gone through a bank drive-through.
I use them all the time.
I just use the ATM. I'm sorry.
It's a drive-through.
That's part of the drive-through.
Yeah. So, but you know, they're the bank drive-throughs are going to last longer because people are doing transactions and stuff there. So, but you know, I just don't know how to make an educated decision with. I know Taco Bell, and I know Taco Bell at 2 a.m. from college. That's my level of knowledge.
Right.
All right.
And just concerns of the extra traffic that it will or won't. I mean, I understand that we want more traffic and we want more business in Concord. I understand that. And balancing, is that location the best for a drive-through restaurant with the infrastructure already set?
Right.
Balancing the two.
Okay, anything else?
The lot's been vacant for how long? 2011. back when in
Forever.
2009, so.
Forever.
Yeah.
Good discussion.
Okay,
Proud of us.
all right. Okay, if there's nothing further, Mike, you want to take a roll?
Sure.
For a vote, or whatever?
Whatever you want to call it.
Whatever you call it.
Mr. Goley?
No.
Mr. Sweeney?
Yes.
Ms. Garkar?
No.
Mr. Rowan?
Yes.
Mr. Czakowski?
Yes.
All right, thank you very much. You have been,
200, give or take.
That's from the.
That's peak hour, but like for the day.
you're successful, you
But you
can
tell
leave.
good to go.
you can actually go.
Yeah.
You're free to go.
I said how many cars per day, and then big hang up was peak hour.
Mr. Traffis, any,
You're not done yet, so I just wanted to make sure you knew.
Thank you. I appreciate you doing that.
oh, we have to,
The other part. Wrap up here.
We have one more item on the agenda and or table plus
Yeah.
minutes,
well, all right.
which we need to table minutes too. What?
The next matter on the agenda is the election of chair and vice chair.
We should wait for Yvonne again.
All right, we will table that.
Well, do you have something to say, Wayne?
I was gonna vote.
Oh.
I don't think you can.
kidding.
Wayne.
And we were not provided the minutes for the March 13th and April 10th, so that it will be tabled as well. The next Board of Zoning Appeals meeting is June 12th.
Is it Thursday right now?
We're all adjourned. Thank you. You can all go home.
About an hour and 15 minutes. And then it's Thursday.
Hour and 7 minutes to be exact.
Oh, yeah.